be the ice cream truck legislation. And just a note that some of this testimony may get very emotional. And I know, and I'm so proud of every single person on this committee, that when we receive this personal, heartfelt testimony, that we really extend our love and welcome to those individuals who may need some kindness from us today. And with that, I'd like to send it over to my co-chair, Senator Anwar. Anything you'd like to say today?
Thank you, Madam Chair. Just wanted to thank everybody for being here and all the speakers who are anticipated to speak. We are here listening to you and looking forward to hearing from you. Thank you, Madam Chair.
Thank you so much to my esteemed co-chair. We do have some business to take care of by reading the rules. As always, meetings will be conducted at a slower pace to accommodate the quality of the live stream and to preserve the integrity of the vote. Although we're not voting, and I hope you guys can still hear me because I seem to have froze.
You're good, we hear you.
Thanks. It's always frozen on the worst picture ever. All participants should be muted until required to speak. Members must raise their virtual hand to signify a desire to speak and wait to be recognized. To do so, please open the participant pane and click raise hand at the bottom of the panel. If for some reason I do not hear or rather see your hand raised, kindly just let me know. The use of emoticons, as in clapping hands or thumbs up, is not allowed. And the use of chat, either public or private, is not allowed. And all chat records are saved by default and therefore could be subject to FOIA requests. After those rules, I think I'm just going to pass the mic for 1 second. If any of our ranking members want to say a few words, Senator Martin.
I am good to go. Thank you, Madam Chair, for the opportunity, though.
Absolutely and always. Thank you. Rep. Dauphiné.
Thank you, Madam Chair, and I'm all set as well, ready to go. Thank you for asking.
Excellent. Thank you so much. And with that, I'd like to ask our first person to come on board, and that would be Commissioner Durantes of the Department of Children and Families. Hi, Commissioner.
Hello, good afternoon, Representative Linehan. To Senator Anwar, great to see you. To Senator Martin and Representative Dauphiné, and to the honorable members of the Committee on Children. Hello, everyone. My name is Vanessa Durantes, the Commissioner of the Connecticut Department of Children and Families. And for today's testimony, I am also joined by our Bureau Chief of Child Welfare, Tina Jefferson. I will be testifying on Senate Bill 2, an act concerning social equity and the health, safety, and education of children. The department appreciates the General Assembly for bringing children's mental health to the forefront of this legislative session. As the state's lead agency on children's behavioral health, DCF has built a broad service array to provide care to children struggling with a wide range of mental health diagnoses and to help their parents navigate a complex and somewhat fragmented system of care. We have also worked to reduce the stigma associated with mental health treatment and believe that children and their families should feel as comfortable seeking assistance as they do when they need medical care. With that in mind, DCF supports the concept of additional mental health training, including suicide awareness and prevention training. We are in favor of providing information to families on how to access services in their communities. Additionally, we support Section 22 of this bill, which allows the department to conduct virtual parent-child visitation when public health emergencies are declared. In fact, this was facilitated by DCF, foster parents, and service providers throughout the COVID-19 pandemic and has demonstrated to work, although in-person visitation remains ideal, of course. We are, however, opposed to the following sections of Senate bill, and we believe they are detrimental to the safety and well-being of children. Section 23 requires DCF to develop a system for our child abuse and neglect hotline or a care line to receive reports via text message. Given the reporting requirements associated with making a report of abuse or neglect, this is an impractical and inefficient solution. The department requires significant information to determine if a referral meets acceptance criteria, a requirement that could not be met within the unstructured platform of a text message. The care line utilizes a screening process by which a social worker asks a series of questions of the caller, including seeking demographic data to verify case participant information, and to assess the department's potential last involvement with the family. This is done to determine if the report meets the statutory definition or criteria of abuse or neglect in order to commence an investigation. In many instances, it would be exceedingly difficult for the social worker to determine whether the report should be accepted or investigated based on the content of a text message. Texting would not allow for the appropriate level of assessment and detail needed to ensure accurate information. The current screening process ensures that the correct reports are investigated while guarding against DCF becoming involved with families unnecessarily. If we are unable to properly screen, we would risk sending investigators to homes without sufficient knowledge of the situation or investigating families unnecessarily. Section 24 requires DCF, when considering removal of a child from his or her family home, to send written notice to the parent or guardian. It is important for the committee to know that unless there is immediate risk of harm for children, DCF puts significant resources and supports in place to empower and assist families to keep children safely at home. Of the approximate 13,000 families that DCF contacts a year, only 9% experience any type of child separation. And those children that are separated, the primary goal is still timely reunification. We are proud that our efforts resulted in the majority of children who are separated from their parents have returned to their homes with supportive services in place. Further, we are concerned that the language in Section 24 is vague and the term removal meeting is overly broad. When it is believed that a child cannot remain safely at home, the department conducts what we call considered removal meetings to establish a plan that addresses to address the safety factor or factors, to prevent removal, and to give the parents options to mitigate those safety concerns. Due to the urgent nature of the considered removal meeting, DCF staff calls the parents or guardian to notify them of this meeting and encourages them to invite extended family members or other family supports to participate. Attorneys for the parents or guardian and the child are also invited if the participants are represented by counsel. Our efforts to divert removal through this process have been hugely successful. In calendar year 2020, 82% of considered removal meetings were held pre-removal, resulting in children being diverted from DCF custody 73% of the time. If a considered removal meeting could not be held prior to removal, it is due to imminent danger requiring that the child be protected. However, the family is invited to a considered removal meeting after a placement has occurred to determine if supports can be implemented to have the child return home safely. Written notice would delay this process and could cause the child to either remain in a harmful situation or to remain in care longer than necessary. A vital component of the considered removal meeting is the participation of extended family members or friends. Parents invite the family and friends they believe can support and assist them with overcoming the safety factor that's been identified, and also be assessed as possible kin placements for the child if necessary. Connecticut is proud that 45% of the children removed from their parental home are placed with kin in this state. DCF strives to have 70% of children in custody with their relatives as we continue these efforts. If this bill advances, we would like to work with the proponents to amend this section to comport with the existing terminology and practice. Section 45 establishes a task force to study the needs of children, but does not include DCF as a member. We presume this may be an oversight, as the department should participate on any group that is exploring ways to improve the lives of children. In fact, as part of formulating the Connecticut Prevention Plan under the Federal Family First Prevention Services Act, we have engaged and continue to work with over 350 stakeholder partners across 5 subcommittees by conducting town halls and focus groups as well. The state plan focuses on reducing child maltreatment, increasing prevention services, reinforcing kinship supports, and strengthening the state service array. Additionally, several provisions of the bill would require unbudgeted funds for the department to carry out. Section 1 requires question, persuade, and refer, or the QPR training, to be administered by the Youth Suicide Advisory Board in each district Department of Health. QPR training is not free, so funds will be needed to provide the Youth Suicide Advisory Board to hold the trainings, or municipalities to have to pay for them. Also, if DCF is expected to accept text notifications through CareLine, a system modification would need to be undertaken. Lastly, several sections of the bill regarding children's mental health screening and services. DCF works closely with partner state agencies to refer families to services to assist families in navigating the procedures of their private health insurers, Medicaid, or other forms of public assistance. It is often stated that Connecticut has one of the best provider networks for children's mental health in the country. We ask the committee members to refer to the Connecticut Children's Behavioral Health Plan, which includes several ideas to improve behavioral and mental health services for all children and their families, including those committed to DCF. Compiled by the Connecticut Children's Behavioral Plan Implementation Advisory Board, the plan and related progress reports can be found in a link attached to my written summary, a written testimony. So thank you for the opportunity to appear before you today, and we are happy to answer any questions.
Thank you very much, Commissioner. I very much appreciate your testimony. I'm confident there's going to be questions, and I know that Senator Anwar has some. I'm going to ask Senator Anwar to begin with his questions, and if they're not covered, I'll go after him with my questions. So Senator Anwar?
Thank you, Madam Chair. Thank you, Commissioner, for your testimony. We appreciate your you and your department looking into SB2 and reflecting on some of your perspectives. I wanted to talk a little bit about these virtual visits that we have had, and I think some of these questions would be more for the committee's benefit, but also the public's benefit. One of the fears everybody has is in the last 12 months that we have been all locked down, there are children who are unsafe because they have not been in-person visits. Would you be able to speak a little bit about that? And then maybe you can touch about the remaining part of the pandemic and post-pandemic, what can we learn from the virtual meetings and their benefits? And then if the bill can be tightened around that.
Thank you, Senator. I appreciate the opportunity to talk about what we've learned about virtual visits. And I would ask our Bureau Chief of Child Welfare, because she has regular meetings with our office directors to talk about this almost every day. So Tina, can you respond to the Senator's question? And then I'll add if there's anything else that you may miss.
Yeah, great. Good afternoon, everyone. Pleasure to be here. I'm really, really proud of the work that we've been able to do related to virtual visits and assessments during the pandemic. One of the first things we did is we were able to really speed up tablet distribution to all of the social workers in our department. And we also made sure that they all had iPhones that give them the ability when families have the capability to FaceTime. And so with the tablet and with the iPhone, we've been really, really successful with virtual contact with our children and families. I think we were all nervous at the start of the pandemic around whether or not we would be able to successfully assess our children and families during this time. But I could tell you that we've been really pleased with the result and with the outcome of our ability to assess families during the pandemic virtually.
Tina, if you don't mind, that's a qualitative answer. Could you give me a little quantitative perspective? And were there areas where it was felt that my understanding is the gold standard would always be in-person visits? What were the number of visits per family, if you will, and the frequency? Did that increase because it's easy to click rather than drive up to a place?
I didn't come prepared with any actual statistics on the number of visits. What I can tell you, though, is that we were able to maintain the same level, if not increased level of contact with our families virtually. We've maintained oversight through our strategic planning division around the number of visits and contacts that we've had with families. We stood up a triage process to ensure that we were assessing the need to still make contact in person when necessary. So that triage included an assessment of whether or not we could access the family. So we never stopped going out in person when the need was there, when we couldn't assure safety of children virtually. I know that we increased our communication and contact with all of our caregivers during the pandemic to make sure that we knew that the children in their homes were okay. We increased our communication with providers that were also working with the families and standing up telehealth visits simultaneously. I'm sure that we could get you the actual numbers at a later date.
Senator, that's what I was going to add to Tina's testimony, Bureau Chief Jefferson's testimony, that our Strategic Planning Bureau has that data, and we can get it to you.
Thank you so much, Commissioner. The next question I had was with respect to the, let's talk about post-pandemic,
Yes.
and hopefully we can at least begin to have those conversations. Um, um, do you foresee the in-person, we'll go back to the in-person because the issue is so critical for the DCF clients to have in-person meetings. Do you foresee a lot of supplementation through these virtual meetings?
What I see is the ability to have that in our toolbox. In-person visits are preferred. Our providers say that, and we say that. The one thing that we've learned in talking to our families is that some of the power differential is leveled off when they're speaking with us, and they've been much more candid and open because of the lowered level of anxiety of DCF showing up at their door. That being said, we've also had continued case review by our federal court monitor during this time, who has monitored the quality of our visits during the pandemic and is able to make comparisons before pandemic and during. And he has reported back to me that he feels that the quality of our visits is sustained. But I will say the one thing that I think is a benefit to a virtual meeting, and those are those administrative case reviews that we held every 6 months on a case. So it's basically the opportunity to work with our families for their case plan. So we have the case plan that we've developed with the family, and we typically hold those meetings with the facilitator, kind of talking about what the blueprint is for the services that are involved and how the family is progressing. Those have seen a marked increase during the pandemic because of this virtual environment that we're in. And I could see that being one of the things that we might leave virtual in terms of being able to convene everyone on a scheduled time period that really does eliminate the ability to have to get childcare or work around people's schedules. We've seen a tremendous amount of participation that I think is really helpful. So the short answer to that is yes, we would love to resume in-person visits when it's safe, 100%, but we'd have a complement of virtual abilities in our tool chest.
And thank you, Madam Commissioner. So the next question I wanted to ask was, what is the waiting time for the phone calls to be made? Because my understanding is that the wait is long enough that for somebody to feel safe, it may be easier to text than to wait online, especially if there's the person who is in the situation of abuse. Texting is very silently and quietly done, and we want to make sure this is how and I think maybe some of my other colleagues may be looking at this.
Yeah, certainly. And what you're referencing is the wait time at our care line. And we recognize, so when I was appointed to this seat, the department had kind of the perfect storm. We had an antiquated phone system. We had changes to our mandated reporter laws that we saw some pretty high profile cases of mandated reporters who had failed to report, and there were consequences to that. So the consequences for failure to report, changes to our mandated reporter law, and an antiquated phone system at that time resulted in wait times that were way too long. There were people who were telling us they were waiting for hours to get through. Since that time, we have spent a lot of time working with our school districts around reporting. We've stood up an online reporting portal for certain parts of mandated reporters. So our school system, our family relations through the court, and police also have a way to be able to contact us differently than they did in the past. We have an updated phone system that is brand new, that has cut wait times down to minutes, and we can provide you what that wait time is right now. So I'm confident with our online portals, with our ability to have certain aspects of our reporters contact us in a different way, and with a better understanding and conversations with our mandated reporters about the suspicion of abuse or neglect and what that actually is. We believe that we've alleviated the wait time issue. And with all of those components can get you the data of what that time is now.
Madam Commissioner, here's my fear. Look, the next generation is more comfortable texting than they are making a phone call. And text would take 3 seconds to say help needed from somebody who's already in your system. And so your premise that this part of the law that we are proposing is actually going to be harmful, in my opinion, it's going to be more protective. Is how I foresee it, and that's why I'm going to gently push back on this to say that look, for somebody who is in a difficult situation, this is an area that we really need to make it easy for somebody who is in abuse or neglect situation to reach out for help. And then we have our own machinery. If we need more resources for the machinery, we do what we have to, but we cannot just wait for somebody to make a phone call who are a victim.
So, Senator, I appreciate that, and neither do we. One of the things that we have said routinely, and I would still say today, that if someone is in immediate danger, they contact 911, and that we and the law enforcement often respond to those situations jointly. So if someone is in need or of immediate danger, the contact to this department would result in us calling the police to go with us at that time. So the messaging around someone being in imminent danger would still be 911, and the police and DCF can go jointly. Using the text system to generate a call of abuse or neglect may inadvertently create unintended consequences of our system having calls that would increase the volume of what comes in that may not reach the statutory definition of abuse or neglect. So as I read that, I was thinking less about the person that's in imminent danger. If someone's in imminent danger, 911, I 100% agree with you. But to enable text messaging, it would be, I just saw a child run out into the street. I'm going to call DCF on that. And that would not be something that would be accepted by our care line without much more discussion with the person who is calling that in to determine the context of that situation. What I fear is that enabling a text message, it would be beyond what you're describing, and it would result in more families being unnecessarily reported to the department. When someone needs immediate assistance, 911 is what they should call, and DCF and the police will come together and they will respond jointly. This is, typically what we do.
Thank you. And then the final question in the first series of questions, I thank you, Representative Linehan, for allowing me to indulge. For the consider removal meetings, that is probably one of the most scary meetings for a parent and a child. And not having the parents know their rights is a little tricky, and some of the individuals who may not be as articulate in their ability to share their perspective makes it very difficult. And there's probably a way to do this so at least they're aware of their rights and then have that opportunity to know about the potential legal support that they could get from pro bono lawyers if they're unable to afford one. And that's the vision that we had when we proposed that. So we want to make sure that people don't have consider removal proceedings without due process, if you will. And that was the rationale.
Certainly. And this gave us an opportunity to talk to you about the considered removal process. This is another area where I think Bureau Chief Jefferson can offer some context for where we were as a system and where we are today. So if I may, Senator, when I was an investigator myself, if there was an allegation of a safety concern, I may show up at someone's door with the police and with an administrative 96-hour hold in my hand and saying, we're here to remove your child. That was that was years ago. Since we have instituted the considered removal practice, we actually do increase the ability to talk to parents about the serious nature of why we are concerned about why a safety factor has to be identified. And during that process, you do talk about the due process rights. You do talk about what will happen if we can't divert the child from coming into care. And this is a process that I do believe has kept children safe safer and diverted children from coming into care. Tina, can you talk a little bit about what that process looks like to give the committee context of what the considered removal process is?
Absolutely, Commissioner. As the Commissioner indicated, we have come a long way with engaging our families and giving them the opportunity to have someone that they're comfortable with come with them to these meetings. So let's say, for example, you have a child in a hospital and the hospital is presenting safety concerns for that child returning to the care of mother. We'll talk to the hospital, we'll talk to mom, we'll let her know, listen, there are some safety factors that have come out during the investigation of your infant. Who do you want to bring to the table? You could bring, clearly, of course, the father, but you could bring grandma, you could bring your minister, bring anyone in your community, your sister, your aunt, whoever you're comfortable with having at the table. So if most of these families are not already court involved, and that's one of the things that we're also trying to avoid is unnecessarily bringing families to the attention of the juvenile court unless it's absolutely necessary. So if they have an attorney, great, they can come. But if they don't, it's really a collaborative meeting. We have written brochures that describe not only a parent's rights, but also what the considered removal process is like. Those meetings are facilitated by our staff, and we bring all the folks together to the table with us. We make sure that the families are clear about the fact that there will be confidential information that will be discussed at this meeting. So if you're uncomfortable with any of the people that you've invited hearing this information, we let them know in advance that we are going to discuss the information that led to the department's involvement. And during the course of that meeting, we really talked through, who can do what. So for example, if the safety factor is parental substance use, then we're talking about who can help mom to safeguard this child. We could talk about what intensive substance use services we can put in place while simultaneously ensuring that the child is not supervised solely by that parent that's also trying to address their substance use issues. We get sort of in the weeds around, who could transport for hospital appointment, who can make sure that they babysit, who can move in. Quite honestly, I think grandparents step up quite a bit in these considered removal meetings to say, I will do whatever necessary to keep my grandchild from being removed. So I'll be at mom's house. We can develop a schedule together. I hope I'm not going into too much detail, but I just wanted to give you a sense of how those meetings go. And families really appreciate the opportunity to have these discussions. And as the commissioner indicated, very often these discussions, when we come up with a plan that mitigates the safety factor, then it prevents the family from ever having to touch the juvenile court.
Thank you so much, Bureau Chief Jefferson, for your words. Sorry, I referred to you as Tina first time around, so it was easy to see. But thank you for your testimony and thank you for clarifying some of those things. I may have more questions, but I think this is time for our chair to weigh in on some of the thoughts as well. Thank you so much.
Thank you, Senator.
Thank you so much, Senator Anwar. I do have a few questions, and I guess that I'll start with the commissioner, but I think that Ms. Jefferson might also be part of this answer. We're talking now about having the lawyer present. So I kind of want to walk through this for a second. So you're saying that there's a written brochure that is given to everyone prior. I'm going to break it down, little questions to get to the big thing. All right, so I love it because the commissioner is laughing because she knows how I operate. So there is a brochure that is given to the families when the meeting is facilitated by staff, correct?
There's a brochure that's entitled "The Parent's Right to Know" that's given at every investigation. So, the contact related to a considered removal meeting is further down the line, because that's when a safety factor has been identified. And once a safety factor has been identified, that triggers the need for a considered removal meeting.
Okay, so put a pin in that for a second. We'll come back to it.
Mhm.
So then we're saying that when this removal meeting happens, that everyone is entitled to bring whomever they choose, right? And that could be familial supports, which are extremely important.
That's
And
right.
it could be a lawyer, correct? If they
It
so
could be.
desire.
If they so choose. Right, because the lawyers that are appointed in juvenile court are only after if we end up in court on that particular case. So the reason why I included that is, of course, if a family wanted to bring legal counsel to one of those meetings, they are open to do so. But typically they're not part of the juvenile court process as yet.
Okay, so that's where we need to unpack this,
Mhm.
because not all of these initial meetings for removal go to juvenile court, right? Because sometimes you're not removing the child.
In fact, on calendar year 20, 73% of the children involved that have had a safety factor identified and had a considered removal meeting had conversations that happened during that meeting that mitigated the safety factor and resulted in that child remaining safely at home or in some family arrangement. That's huge. If
That
not
is
for that
huge.
process, the child would be brought into foster care. And in situations, we know that a removal is, it could create additional trauma for a child.
So, and I agree with you. And the work that you guys have been doing to get that number up is phenomenal. And I know it's still not even exactly where you want to be. You even want to make that stronger. And
We do.
I commend you on that. But
Mhm.
here's my question. How does it hurt to have a lawyer present in that meeting? Does it hurt at all?
I don't believe it hurts, but I also believe that, that would mean that we would have filed something in court. And
But not necessarily.
we have not prevented lawyers from being in the meeting.
Right.
So,
So really,
yeah.
oh, I apologize.
Sorry.
There's a
Yeah.
little delay. So it's like we're stepping on each other.
I'm so sorry.
But you're right? So I think there might be just a disconnect, because we're not asking for the court involvement. We are asking for the ability for a parent to be notified that there is a group of pro bono lawyers who
Mhm.
are happy to come to that meeting, so that parents feel that they are adequately represented if they're not completely understanding the process. So I think that we can kind of fix this whole thing, right? If we then say in that written brochure at the beginning of any investigation, that brochure discusses what might happen in this removal meeting, and just simply gives a website so people can know where to contact these pro bono lawyers should they get to the removal meeting and want someone there for them. It's
Mhm.
not bringing them into the justice system. It's really just a way of saying, hey, parents, in case you're not understanding what's going on, here's someone who is willing to be with you through the process, in addition to all that familial support going to the meeting. Would that work for everybody involved?
So, what I will do is I will make sure that the committee gets a copy of what the parents' right to know brochure looks like, and if that should be amended to include a section of, if should a safety factor be determined to consider, and explaining that process. I will be candid, if you don't mind, Representative. One of the concerns I would have is if we never refuse anyone's attorney to be present at these meetings. But as Bureau Chief Jefferson talked about, we get into the granular detail of what our concern is. And I think out of protection of their client, oftentimes, and this is, not, speaking out of turn here for any attorneys that are present, their role in that particular situation may say to the parent, don't talk about that. And that would prevent us from being able to mitigate the safety factor out of protection from, whether it's incrimination for whatever the situation is. And they are in the role of of trying to protect that parent. In those situations, I'm looking for my staff to protect the child and use the information gleaned there to determine, is there anybody who can come in and help mitigate this safety factor? Sometimes when an effort to try to ensure that the parent has their rights upheld, would we be limiting their ability to be able to talk freely about the help they may need to ensure that their child is safe? I would never discourage anyone from bringing an attorney, and we have attorneys that often will sit in on considered removal meetings, but to ask what could it hurt, there could be some negative unintended consequences to that. I'm very
Okay.
proud of where the department has come in terms of the ability to divert removals, and I'm not sure that trajectory would continue if that was an expectation every time. With right now, our doors are open and allow for that to happen.
All right, that's a good point, and that's why we ask these questions. So thank you very much for that. What I would like to do is after this meeting, kind of facilitate a conversation with an attorney who actually was the one that brought up the fact that he wanted to be in these meetings to help parents. This actually came from an attorney who does this pro bono work, who just feels that there are so many parents who just don't know their rights, and he wants to help. I don't think he sees it as adversarial. So we'll just connect in a meeting and see what we can work out there. And then let's talk about the text line.
Yes.
So I get what you're saying, and I do agree with it. I think because the way the bill was written, it looked like we wanted a text line to be able to report things to the care line. That was not the original intent. So give me a sec to explain the original intent.
Okay.
So if you've got a child who is already in foster care and they feel that they are in a dangerous system in foster care, right? We wanted the ability for those children to reach out to DCF easier. I recognize you said everybody should contact 911. Maybe it's not to the point where they're in imminent danger. Maybe it's to where they're saying, this isn't working out. Let's do a fun example time. I'm an LGBTQ child. I'm just starting to come out, and my foster parent is having a problem with that. And now I'm afraid to actually be who I am. And so they're going to reach out to DCF to say, you know, I'm supposed to be in your care. Here are the concerns I have, and I'm not comfortable making those concerns in front of my foster parent. So I need to have a line to say, these are my concerns. The reason why we want this is so that there's a better relationship between foster children and the Department of Children and Families. So is there, and I know that that these text lines can be easy as a computer system. I mean, we've all done it in campaigns. It's pretty easy. And I don't think it would cost a lot of money. But where the money would come in would be the staffing of it, right? And I think that these would have to be people who can talk a child out of a crisis situation. So it could be kind of an all-encompassing text line. If we were to continue to work on this and figure out the right way to implement it, do you think you're more on board with it, given the information that I shared with you now about where we want to go with it?
That's totally a different context than I understood when we read it. And I also have some information that I believe that will help to further contextualize this. So our Adolescent Services Division has recently been renamed, and an adolescent practice model associated with that. It's now the Transitioning Youth for Success Division, because we wanted to make sure that older youth in care have exactly what you're talking about. The tools needed to be successful academically, to be successful emotionally, and to be successful medically. And with that, we recognize increases to their ability to have contact and to express when things aren't going well. So encompassed in this new adolescent practice model are things like apps that they can contact different parts and different resources. We've included, what I'm really excited about is a youth ombudsman, where they're training peers to take calls from teenagers in care. So these are kids that are in care, that have been in care themselves, maybe foster care alumni who, when you talk to a teenager, it's a different conversation, especially when you talk to someone that has lived experience. And we are training them to be able to kind of field some of those calls through our Office of Community Relations to be able to hear exactly what you're talking about, because we heard from some older youth in care who had some of those concerns in the past. We are beefing up the expectation of what happens with their adolescent services worker and the context they have with our older youth in care, consistent with a national attention to older youth in care and the connections that they need. We are moving away from this independent living model to who are the people in your life that you can grow and make mistakes with and catch you when you do some of the things that we know teenagers do. So our adolescent practice model and the revisions incorporate some of those things that you talk about: technology, apps, better ways to communicate with their worker, with their foster parent, talking to foster parents about fostering teens and how that might be different than just a general foster care license. So many of the things that the committee sounds like they were concerned about are underway in this adolescent practice model that I believe gets to exactly what you're talking about.
Yeah, that actually sounds really, really great. I'm so glad you're doing that. Great work. Thank you so much. Just a few follow-up questions on that. For the app, is that direct communication, or is that you send it in and then there's like a lag time in response?
So that the app piece is under development. And so I think it's hearing the concerns of the committee gives us an opportunity to see if there are apps that are currently used in other jurisdictions. There are a growing movement of foster care alumni who have really talked about what it's like for older kids, older youth in care. And actually, one of the leading voices nationally came from Connecticut. Sixto Cancel is out there, and I can share some of his work about how to develop an app that gives them resources, creates a network of them to talk to each other, and then how to talk back to the department. So incorporated in our adolescent practice model, we'll have to determine which types of apps would fit the needs of the kids in Connecticut. Those youth ombudsmen have been onboarded and they are undergoing training, and they are part of the community relations division already. And the adolescent practice model has been developed. The piece that involves the tools inside are under development. And this will help us actually make sure that either we take something that's off the shelf or create something that is unique to Connecticut, or a combination of both.
And how long have you been working on this so far?
So the adolescent practice model has been the last few, like the last year. It's so hard in COVID time to really know how long we've taken to do anything. It's almost like, so at least during this, during my tenure, we've had an opportunity to really dig deep and build up our adolescent services.
And when do you foresee it ready to launch?
We're launching. I can send you a copy of our draft, and then the component pieces like apps and those types of things are things that we're getting guidance from our teens that are here with us to say this would work, this wouldn't work. We've actually included teenagers in our Academy for Workforce Development curriculum development. Sit in as we talk about training our staff, be part of our scenarios that we've shared before of how to work with teenagers in care. We've included an adolescent on one of our fiscal services committee because one teenager said to us, what you guys give us for a class ring doesn't even pay for all of our senior activities, and I've had to go without and my peers don't. So we incorporated a teenager to be a part of those fiscal discussions about what that's like. We've incorporated a teenager to meet with the banking commissioner on financial literacy and how to really develop checking accounts, because a lot of them said we're having trouble getting accounts, and the banking commissioner said, you don't just want to open the floodgates, you want them to be responsible and fiscal acuity. So I'm so excited, if you can't tell, of the work that we're doing to try to build up our transitioning youth for support for success, that we can share of what that looks like, but we're ready to launch that any day now.
That's really great. I'm so happy to hear this. I wish I had known before. Keep in mind that this legislation, if there's something that you need in order to beef that up or get it out appropriately and as fast as possible, as strong as possible, to really, really help those kids, let us know if there's something that we need to put in this legislation to help you do that budget-wise. But I will say this, I really have to point that we need a direct text line. So through that app, if there is direct messaging, that's going to be hugely important, because as someone with a preteen right now, I can tell you they're not very good at waiting.
Mm-mm.
If they're having an issue now, they want an answer now. I mean, it's like that with most adults, but we don't want to lose a child because there is a lag in time of hearing what they need and what their issues are. So I think that this app or this program needs to recognize that there are very short-term needs that it needs to fill, and then the longer term needs. And it seems like you have the longer term down, but we really need that crisis contact for these kids. And I think that a text line to a real person is really helpful. And that should honestly be also staffed at nighttime.
Let me talk to my transitioning youth for success about accessibility and how that's been built in, because one of the directors that we brought into this particular division was most recently managing an adolescent services unit in one of our larger offices. So she has real-time experience. These aren't people that are just trying to develop this from what they think in theory, that they've worked hand in hand with some of the crises that kids might experience while they've been in care. So let me find out. I'm talking about it in very general, loose terms. I can find out from you, from the people who've actually been creating this, where they are in that particular issue.
That'd be great. Thank you so very much. I really appreciate you taking the time to explain all of that. I think it sounds wonderful. So
I'm
thank
excited.
you for your work. Representative Dauphinais.
Thank you, Madam Chair, and thank you, Commissioner, for coming to speak with us. Appreciate that. I know you said you supported the bill with the exception of the sections that you mentioned, and I realize you didn't write this bill, but I wondered on lines 29 through 297 to 299, I wondered if you could comment, why should there be no parental consent for this, but they are required for most medical appointments with regard to that mental health services and now patient clinics? Would you mind commenting on that?
I'm sorry, can you repeat the question? I'm not certain what the question is. Yeah.
From lines 297, 298, and 299, it talks about that there will be no consent from parents needed to have, I think there's 6 total sessions with a child with regard to outpatient mental health treatment. I just wondered, I'm assuming that you support that as well, and I wondered that why there should be no parental consent for this, but they are required for most medical appointments.
I think that's referencing our school-based health clinics, and I think the way that that has been written is the way the school-based health clinics were designed originally. So I think that section of the bill specifically speaks to the services of school-based health clinics and the ability to continue to talk to children while they are in the moment of needing some particular assistance in a school-based setting. So I think that's specific to that.
Yeah, I think you're right. I just wondered, why no parental consent needed there, but for most medical treatments. I'm just wondering if you could speak to that a little bit.
I guess I would have to ask the department's legal division around that to speak more specifically about what we would consider a concern about that, particularly for the children that we have in care. But I know that the school that specific passage is about school-based health clinics and their ability to kind of talk to kids for a finite number of sessions.
And are you aware, or do you know when they talk about a minor, are they talking about a child of any age under 18, or?
I would imagine so. I would imagine so, but let's get clarification.
Okay.
On the definition there.
And I mean, I'm understanding that this is probably to make provisions for children that might be under abusive situations where they have a place to go and talk. I'm assuming that this was written specifically for children that are in situations that might be occurring in the family, that they need to talk to somebody outside the family. Do you think that there should be any provisions made for parental consent when it's outside of that purview?
So Representative, thank you for that question. I will say that because we didn't author the bill, one of the things that you've heard and hopefully in our testimony today is that the interpretation of how we read the bill, we offered commentary and testimony on the sections that we found most problematic or the ones that we would support. And today we've had an opportunity to talk about that further. DCF is responsible for not only child protection on those cases that come to our attention in the child maltreatment arm, but we're also the children's behavioral health statutorily mandated for that. So that is all children in the state of Connecticut for that component of it. The piece that you're referencing are school-based health clinics and that they are already in existence.
Understood. Thank you so much, Commissioner, and thank you,
Thank you.
Madam, for the time.
Thank you, Representative.
Thank you very much, Commissioner, and everyone that came with you. We thank you guys for your time, but seeing no more questions, I think that's all for today.
Thank you very much.
Thank you so much. I will just make note that we are at 1:54. So after our next person, Representative Borer, we're then going to bounce back and forth between state and elected officials and the general public. And with that said, I'd like to welcome Representative Borer. How are you?
I am good, and I am so glad I was sitting in the queue because I got to listen to all of the great work that the commissioner and the committee is doing. You know, you're always,
Agreed.
you know, you have so many committees going on, and you don't always necessarily get to hear about all the great work. So, so that was great. Thank you. So,
Sure.
So I want to say hello to all the leaders and the members of the committee today. As Representative Lenihan said, I'm Dorinda Borer. I'm the representative from West Haven, which is the 115th district. And I want to thank everyone on this committee, especially Representative Lenihan, for raising and leading the way for Bill 6566, which is an act concerning children's safety and ice cream truck practices. I'm here to join you in strong support, as I believe it's imperative that we secure the passage of Bill 6566 through committee to avoid future horrific tragedies such as what occurred last summer, whereby Tristan, a young boy from Cheshire, was fatally hit by an oncoming car while innocently buying ice cream. When ice cream trucks come into high traffic neighborhoods, the risk of a child getting struck by a motor vehicle increases exponentially. This bill, modeled after Hartford's ordinance, attempts to address those risks and implements crucial features to improve safety measures, including the addition of convex mirrors, a requirement that those who are selling disallows those selling to children from selling to children across the street, a requirement of a stop sign arm on the ice cream truck to be used, and more stringent road regulations on speed. Those are just a few of the examples in the bill and components of 6566. This tragedy, unfortunately, is one of many occurrences seen across the country, and states have begun passing legislation improving safety surrounding ice cream trucks. Our tri-state area neighborhoods, along with California, have all passed strict legislation regarding ice cream trucks, with signs and speed being regulated and surrounding the ice cream trucks, which are a magnet to our young children. My heart aches for Tristan's family and friends and all the families who have lost someone. Tristan's family have taken this tragedy and made it into a significant and have become a significant force behind this legislation to save other children. To demonstrate our support towards preventing heartache by more families and friends and to honor Tristan, please consider naming this bill Tristan's Law. And together we can demonstrate our dedication to the children of our state by passing this legislation. And finally, if the Carano family is listening, I again want to add my heartfelt sympathies to you and thank you for your brave journey in passing this legislation to protect all of our children.
Representative, thank you so very much for your testimony and for your support of this legislation. We will hear from a few today about what the Carano family has gone through, but how they've been so strong in helping to make sure that this doesn't happen to another child. I think that this bill is put together really perfectly. I think that it looks at it from all angles. Representative, are you aware of the safety reports that came from different states that they're already putting some of these things in practice?
I looked at an OLL report that showed what states are starting to implement changes to their laws. Is that what you're referencing?
It is, yeah.
Yes.
And so we already know, given some data within that report, that the states that have implemented some of these provisions have actually seen better safety for their kids. So would you agree that this bill put together is not just grasping at straws and putting together safety things that we think sound good, but that they're data driven?
I think they're data driven, but I also think they're common sense, right? They're common sense protection measures that should have been put in place years ago to protect the children. Crossing the street on a busy road, we have the arm for the school buses. I know that some ice cream trucks do already have that extended arm, but they're not required to use it. I mean, these are just, common sense practices that we need to make into law to make sure everybody's adhering.
I do agree. And there is a part of this bill that has a penalty for non-compliance. We made sure that this penalty was in line with other things that would be within that ilk. And if the penalty for failure to comply is taken out, would you see that as a major blow to the safety portion of this bill?
Well, with any law, there needs to be ramifications if it's not followed, right? So if there's not a significant impact for violating a law, then what would be the deterrence from somebody adhering to it?
I agree. Thank you, Madam. Are there any questions for the good representative? Seeing no questions, but a lot of nodding heads. I thank you very much for your testimony
Thank you.
today.
Thank you for all the work that you're all doing.
Thank you. And now we will start going to members of the public. I do need to remind everyone that there is a 3-minute limit. And one of our assistant clerks, Mr. Jalmar de Dios, will be popping in to say he apologizes, but your time is up. Please note that he is as polite as one could possibly be, and that his job is one of the most difficult jobs in this committee. So thank you, Jalmar. We appreciate you doing that, but the purpose of this is to keep the hearing moving right along. And with that, we ask for a Mr. John Flanders, followed by Sarah Egan. Mr. Flanders, are you with us? There you are, sir. Just unmute your microphone. Oh, there you are.
Is that better?
That's perfect. Welcome back to the committee, sir. Go ahead.
Thank you very much. You got to lip read my mentioning of y'all's names. My name is John Flanders, and I'm a parent and attorney who represents families with kids in special education, and I'm here speaking for Special Education Equity for Kids in Connecticut. SEEK is an organization of parents, attorneys, and advocates dedicated to improving the situation for students with disabilities here in the state. I'm here, I want to limit my testimony here to Senate Bill 2, in particular Section 25 and what follows regarding increasing the birth to 3 services to birth to 5 for students who don't otherwise qualify for special education. We at SEEK read the report of the group set up by the Office of Early Childhood, and we applaud the concept of providing services for these students. We are a little ambivalent about the bill because we're afraid that it will implicate the law of unintended consequences that may not have the proper effects on this, and we hope that it can be amended prior to passage. The 3 problems that we see are, number 1, given an alternative to special education, we are concerned that there will be situations in which a district will decline to identify a child needing special education and refer them to the alternative, which is less expensive and less useful of the school's resources. So families will be moved into this perhaps inappropriately. Second, IDEA has a fairly robust mechanism for ensuring that when each year's plan is developed, there is a firm baseline for where the student is. And while Birth to Three's program, the IFSP, has a similar one, it is less concerned with academics and more concerned with development. We're concerned that if there isn't an academically associated plan that's followed each year while the student is on this, when she becomes eligible for kindergarten, we may not have all of the tools necessary to develop an appropriate IEP should that be necessary. The third problem is an exacerbation of a problem that we've been talking about at SEEK for some time. And that is the Birth to Three providers are prohibited from making programming recommendations at the initial planning and placement team when a child makes a transfer into special ed. That prohibition is a significant contributor into the fact of stories that we hear from families that transition very much resembles falling off a cliff. We think that that's a serious problem for students at 3 years old. We think it will be an even worse problem for a student who's 5-year-old and moving from support services into kindergarten.
Thank you,
So
Mr. Sanders. Your time, allotted time is up. Can you summarize in 2 or 3 sentences, please?
I can, yes. Basically, we would like to work with the committee, with the legislature and the people that wrote this particular part to make modifications that will make it more useful to provide this service and make sure that kids transition into schools with all the tools they need. And I'm happy to answer questions.
Great. Thank you so very much, Mr. Flanders. I really appreciate you being here. I don't think it's any secret that you're one of my favorite people to come and testify. One of my favorite people in general. I think the work that you do is really fantastic. And the issues that you brought up are very real issues. And so a couple of questions to you. I believe it was last year we did have a bill where we asked for Birth to Three members to be part of the IEP process, the original process. So is this obviously it's something you would like to have added to the bill?
Correct.
Okay. The IDEA baseline, this was something that I didn't think about. And you bring up a really great point. So in order to fix this, you had said that that Birth to Three, or now Birth to Five, is less concerned with academics and more concerned with development. So my question to you is, do we then make Birth to Three concerned with academics, or do we have them have a simultaneous track that both things are considered? How do we fix that?
Okay, I think your latter approach is probably closer to what I think is the appropriate idea. My thought process would be to build in a mechanism for what amounts to a PPT meeting for these students while they're covered under this plan. This way, educators as well as Birth to Three providers could look at the student, consider what her needs would be in terms of adapting to schools, or where she stands academically. 4-year-olds are not particularly academically. But if there's this mechanism where the two parties or the two participant agencies are meeting together on a regular basis to look at that student and to look at the kindergarten needs, the first grade needs with relation to where she is in her development at 4 and 5, I think that would be an effective way of approaching the situations. Communication is the best solution.
Absolutely. So given what we think might be a fix for that, then let's go back to the first point that you made, is that if they're given an alternative to special ed, that districts may decline to give them the special ed and refer them to Birth to Three. That is certainly an unintended consequence that we don't want.
Right.
So if we are building this mechanism for a PPT meeting while within the plan between the ages of 3 and 5, then does that alleviate that concern?
I think it does to a certain extent. I mean, for any student turning 3, IDEA requires that there be a PPT meeting to consider whether or not she's eligible for special education. So there's automatically a threshold meeting there at age 3. Our concern is that team might weigh financial and resource issues against student need issues and decide on the former, based on the former. I think that it will help to have that decision reviewed annually. I think it would help a lot, frankly, if there was more money in the process. Betty Feinstein, who will be talking later, is talking about this to the various committees. The way school financing covers special education puts a lot of weight on local property taxes for things that local property tax payers and administrators don't have any much control over. So it's money is clearly a factor. I think it would be great to have the State Department of Education produce some training and particularly specific guidance on this issue. And if they had the resources to do effective enforcement, if bad decisions were made, that would be super. But yeah. So long answer, but the short answer is yes, it will help. But I think other things would help at least as much or possibly more.
Okay, and so can you just, so that myself and the committee members are aware, can you talk about this automatic threshold meeting at age 3? Every child at age 3, or are we talking children that come from birth to 3?
Every child in birth to 3 automatically has this. It's a built-in process within IDEA. About 3 months before the 3rd birthday, the school is notified about the child. A PPT meets at some point in that process, determines what information they need to evaluate whether the child is eligible, orders testing if necessary, and then if more information is gathered, they come back prior to that and design an IEP for that 3-year-old in kindergarten. So only those children automatically have this threshold action. On the other hand, any parent of a child over 3 can call for a PPT to have their child evaluated, and whether they've been in birth to 3 or not. And so there are other mechanisms in there, although parents who haven't run into this may not be aware of their rights in this issue.
Okay, so does your written testimony have your suggestions on how to fix these?
We have not put together legislative language yet with this. We weren't aware that this thing was coming until late last week. So we haven't really had a chance to, but we would be happy to craft some amendments and forward them to you, in the next short period.
It doesn't even have to be anything fancy. Just shoot me an email and saying, this is how we think we can get to the intent of the legislation while minimizing unintended consequences. And so that information will be really, really important. And if you could send that to both chairs, that would be terrific.
Okay, be happy to.
Okay, thank you.
You seem to be frozen, and I have a phone that I don't want to answer ringing in the background.
Okay, this is Senator Anwar. I think Representative Lenahan was going to suggest that I speak, so I'm just going to take that opportunity and speak to Senator Anwar. Thank you, Mr. Flanders, for your testimony and important insight. I can tell you that all the questions that I had, the chairwoman has already asked, which are very helpful. So your email and suggested language would be really helpful to us. I wanted to, because my questions have been answered already, I wanted to ask you another question. With your work that you're doing with SEEP and with the pandemic, are there any acute issues that need to be addressed through legislative priorities?
Yes, and we've talked about them in education, fairly extensively. I mean, kids with disabilities tend to be the canaries in the mine shaft for all educational issues. And everything that you're seeing about kids with remote learning, with hybrid learning, are happening to our kids noticeably greater. The acute need is that we believe that most kids with disabilities are regressing or lacking to progress during this change in educational techniques at a greater degree than a typical kid. On the other hand, there are some kids who are doing really well because it helps with anxiety issues or things. The problem there is regression, and the special ed law IDEA has provisions for regression for being denied services. It's called compensatory education, and what we are trying to do, and it is frankly a very heavy lift, is to figure out how to get that compensatory education into a child's program. How do we get them the services that they need to make up for what they've lost? And that's probably the single most acute factor that we're facing right now.
Okay. And you know, with some of the new federal laws that are in the pipeline and the municipal support that may be in the pipeline, there may be some opportunities to invest rightfully in some of these areas the new areas that we have identified.
Absolutely. We are very much looking forward to the new stimulus bill that got through the Senate in Washington this week. And there's a fair amount of money from the previous stimulus bill that hasn't been expended yet properly. Part of the concern is that all of these things have deadlines on them. And the things that will be most helpful for these kids is additional staff and additional professionals to be able to do this. It's hard to hire somebody to do this work when you know that the funding source is going to dry up in 2 years. So yes, there is absolutely opportunity, and we look forward to working with schools and all of our partners in this to make sure that we utilize those resources as effectively as we possibly can.
And Mr. Flanders, I wanted to clarify, in what you suggested was that the Education Committee is addressing these things?
Yes, to a great degree, okay. Yes.
All right. And if this committee has any role in any shape or form, so please do reach out to us.
Absolutely, and we very much appreciate your interest in and your support on this. There are a number of other issues, and my colleague Andy Feinstein, who's down the list, will talk about those in greater detail.
Okay, perfect. I'm seeing no other questions, and I see Representative Linehan is back, and back to you, Chief.
And let me close by saying thank you very much, Representative Linehan, for your very kind comments early on. You made me blush.
Well, you know what? You're very welcome, but it's so well deserved. You do such great work for kids, and I just appreciate everything you do. So thank you so much.
We're always here for you.
Well, I'll make a list. So, okay. Thank you so much, John.
Thank you very much.
Have a great day.
You too. Bye-bye.
Next, we're going to call our child advocate, Sarah Egan, followed by Alicia Solomon, and then Commissioner Bai. Sarah, hi. How are you today?
I'm well, Representative Linehan. Hello to the members of the committee. Good afternoon. I'm sorry, that light behind me seems to be very bright. I'm sorry about that. I'm trying to block it. My name is Sarah Egan. I run the state's Office of the Child Advocate. It's nice to see everybody again today. For those that don't know, the Office of the Child Advocate is an independent state agency, and the obligations of the OCA are to review, investigate, and make recommendations regarding how our publicly funded state and local systems can meet the needs of vulnerable children. There are many provisions in Senate Bill 2 that my written testimony addresses, though not all, but there are a few that I wanted to highlight in my testimony today. The first being the provision regarding QPR training and the Youth Suicide Advisory Board. As the committee, I think, knows and has heard from the Office of the Child Advocate before, we strongly support the goals of this bill, which seek to train and inform community members and licensed health professionals regarding suicide prevention. And such training is essential to combat the growing numbers of children who seek to end their own lives. Attention to suicide prevention activities is as urgently needed, if not more so than ever, given the emotional burdens that have impacted our children during COVID-19. As we know, suicide is the second leading cause of preventable death for children over age 10, starting at age 10, followed only by motor vehicle crashes. Between January 2001 and December 2020, Connecticut lost 175 children to suicide. Boys accounted for more than 60% of those suicide deaths. And for the past 8 years, girls have been dying at an increasingly similar rate to boys. Youth suicide has a devastating impact to the youth's family, school, and community, and the ripple effect of each tragedy cannot be overstated. A death from suicide is often described as a death like no other, as it may carry shame, stigma, and a concerns for contagion among youth. I included in my testimony some of the statistics from the most recent, it's not from 2020, so it's a little before that, study in Connecticut survey of youth based on the CDC data. I've highlighted some of that feedback from kids in my testimony today, including that in response to a question about whether they had done something to purposely hurt themselves in the past year without wanting to die, almost 20% of children answered yes to that question, with Hispanic youth now leading this category. 26% of children responded they felt sad or hopeless for more than 2 weeks during the previous year. More than a third of girls in the survey answered yes to this question. The percentage of youth who responded yes to a question about whether they had attempted suicide in the previous 12 months, over 8% of children responded yes to that question, with Black children recently leading in this category. As the committee knows, the Department of Children and Families and DEMAS, along with the Office of the Child Advocate, are part of the statewide Suicide Advisory Board, working on these issues, and the board recently unveiled its 5-year suicide prevention plan. As you heard from the Department of Children and Families today, the suicide prevention training does take resources. I would note, and as I do in my testimony, that currently there's no specific state appropriation for the statewide Suicide Advisory Board and the accompanying work that it does. The board depends right now on federal grant dollars. It may be worth considering that some similar work going on in the neighboring state of Massachusetts receives a $4 million line item in appropriation. Funding would go a long way to helping state and local leaders scale up suicide prevention programs and training. I included a few recommendations in our testimony, including giving a specific appropriation for this work to support critical community training efforts, with dollars available to the state agency co-chairs of the State Suicide Advisory Board to implement the goals of this legislation. And while the OCA is not directly staffed or funded to facilitate the training, we do participate in the advisory board and are here to consult with the chairs on the work described herein, and the board can report back to this committee regarding progress with these important provisions. Skipping ahead in the bill, I did hear the back and forth on section 23 of the bill, which speaks to the provision about care line texting. I did, in my written testimony will reflect that I did share some of the same position that the department had about sort of wide-ranging texting of general care line reports. But in hearing the comments from Representative Linehan about what the intent of that provision is, I think that's very interesting, and I'm always supportive of efforts to increase the ease with which children and highly vulnerable people in custody can make reports of things they're concerned about. So I'm here to work with the committee in any way we can to be helpful on that particular provision. With regard to section 23 of the bill, which calls for a written notice requirement before a child is removed from their home. I absolutely understand the intent of that provision as well, as notice is incredibly important to families. Before something like that happens, I just scrolled down too far in my testimony. Excuse me. Oh, you know what? I'm sorry. I just want to go back for a second. I jumped too far ahead too quickly. On the texting, I also wanted to say the texting to the care line, and in particular in response to some of the concerns raised by Senator Anwar as well, I wanted to make a couple of suggestions. One, referencing earlier recommendations made by our office, and as DCF is looking to streamline its legislative reporting requirements, streamlining which OCA supports, and the longtime 1F federal consent decree, which is binding on DCF, is likely to end in this biennium. OCA suggests that the committee conduct an annual informational hearing or more with the department and outline a series of topics about which members will be briefed, including with data regarding critical DCF functions. That could include the reliability and efficacy of the care line and the progress towards, on the efforts that DCF identified here today. 2, the quality of DCF investigation work. 3, strategies to assess and ensure children's safety. 4, the prevention and response to critical incidents involving children. 5, permanency outcomes for children involved with DCF. And 6, implementation of the DCF-led behavioral health plan. Those are suggestions. OCA is available to participate in and support such a hearing and can contribute information regarding OCA's function and activities as they relate to these important topics. Section 24 requires DCF, when considering removing a child from his or her family home, to send written notice to the parent or guardian. Listening to the back and forth before, I want to say that absolutely as much notice and due process should always be used when such critical actions are being contemplated. As you heard, when it is believed that a child cannot remain safely at home, DCF conducts a considered removal meeting to establish a plan to address safety concerns that have been identified and that have raised the specter of children's removal. Listening to the conversation, one suggestion is that perhaps that provision of the bill could be written to specifically state that there is a value in written notice. There's a value in putting information in place as the bill talks about. Perhaps it could be written a little more clearly to say that notice is provided whenever the provision of such notice does not delay necessary actions that must be taken to ensure the safety of a child. And maybe there's some language that can be tweaked there, because obviously whenever notice can be given and doesn't impact the safety of a child, it should be given. I do want to echo that I think the department's practices with regard to considered removal have been a good development, and the majority of considered removal meetings that are held, the child does not come into foster care at that time, and they're challenging meetings to conduct, but their implementation has been a good development for the state. On the birth to 5, this is an issue very, very close to my heart. I listened to Attorney Flanders' comments about this as well. So the Office of the Child Advocate supports the concept of extending the state's birth to 3 services to 4 and 5-year-olds. There is so much that is innovative, effective, and family-friendly in the birth to 3 model that frankly should inform so much more of our service delivery system for children with disabilities or mental health treatment needs. Many parents and children are hesitant or concerned about the transition from early intervention to public school services. Birth to 3 providers are trained to work with the family and child together, provide services in the natural environment, identify goals and objectives with the regular input of the family, and provide multidisciplinary services to support the whole child in the context of his or her family. Let me state unequivocally that we need a lot more of that approach in our whole system. If I could make it birth to 21, I would. Because if we had it, families and children would be better off, and we would prevent inefficiencies and waste down the road from not providing services in that way. OCA has long been concerned about some of the problems the bill is looking to remedy. 1, the lack of continuity for children exiting the birth to 3 system. 2, the loss of services and supports for children with families that do not qualify for special education service delivery upon leaving birth to 3. 3, the lack of robust services on the preschool special education side for children, depending on where the child lives and what school system they are part of. 4, the lack of care coordination for children as they transition away from birth to 3. 5, the loss of parental training and support services for families who have children with disabilities. I know that Attorney Flanders would say that parental training is required under IDEA, but parents don't get it the way that they would with birth to 3. And 6, the loss of services provided in the child's natural environment, home and community settings, making it harder for supports to be aligned and for children to generalize new skills across their environments. And yes, we can do better. I think, as Attorney Flanders pointed out, there are challenges, with the bill as written. And I do question as to whether we're ready right now to do this extension to 5. I would point out that the legislature recently created a task force, Public Act 19-184, looking at ways to improve transition supports and outcomes for children leaving birth to 3, a task force which made several recommendations at its conclusion, and then COVID happened. So OCA makes some of the following recommendations, and I'm happy to help the committee in any way on moving this initiative closer to realization. But one, we need to monitor the progress of the recommendations from that most recent Birth to 3 Transition Task Force to make sure that those recommendations go forward. 2, we could also reconvene the task force with the express goal of examining how to extend services for children through age 5 while simultaneously offering care coordination services to children whose families transition to public school special education services. 3, we could also recharge the task force to look specifically at inequities in the early childhood special education system and to develop recommendations to the legislature to remedy these concerns. 4, we can ensure, and John talked about this as well, ensure that federal education stimulus dollars are specifically utilized by districts to support the needs of early childhood education and special education students, and that the State Department of Education is closely monitoring the needs of this population. 5, implement strategies with new federal stimulus support dollars to allow families to extend birth to 3 services for a period of time, let's say 12 months, who would otherwise transition out of early intervention, and study the efficacy of these extended services for improved developmental and academic outcomes. I can't let my testimony end without also saying that there are so many things that we could and should be doing right now to support pregnant women and children 0 to 5. Extending the birth to 3 system is one initiative for consideration. But right now, we have probably 30,000 plus babies that have been born during COVID, because we average about 36,000 births a year in the state of Connecticut. A significant percentage of these children are born in lower income families or are Medicaid recipients. I know that Beth Bai will be testifying from the Office of Early Childhood. As we look at the federal dollars that are coming into the state, I always think that nothing would make, nothing. One of the things that we should be doing that would make things so much better for children is ensuring we have an interagency, robust, strategic plan for pregnant women and babies age 0 to 5. We don't have that right now. We don't have that. We don't have it on the Medicaid side. We don't have that coordinated strategic plan that says, how are we going to make sure all children 0 to 5 have their needs met developmentally, academically, healthcare-wise, and for housing? My testimony includes a series of recommendations about steps that can be taken right now to push that forward. I'll just highlight a couple things that, with the federal, are there ways to use the federal stimulus dollars to ensure that all pregnant women, all new babies have home visiting in this first year of life, even a number of home visits. Home visiting is a low cost and an efficient way to improve maternal outcomes, health outcomes, and birth outcomes and developmental outcomes for very young children. How can we start getting to more universal home visiting? Can we extend birth to 3 services with some of those federal dollars, at least for now? Extend them for another 12 months and give families that additional care coordination and support, particularly considering that during COVID, a vast majority of services in birth to 3 have been delivered remotely. That may work fine for some children, but it's not going to work that great for children with the most significant level of need. And then to have those children exit to a preschool special education system that in some towns is just nowhere near what it needs to be. Right? So that those children, coming, who have the most significant support needs during COVID and now moving into the next year are still positioned right now to be underserved. And we have to do, we have to, and we can do better for those children. I know I went on for a while. I'm happy to answer any questions that you may have.
Thank you very much. I always appreciate your testimony, and I think that you've given us a lot of really good ideas on how to get to what we really want to accomplish with this bill. And then think of some of the things that we may not have thought of that we really should have. And we will take you up on your offer to work with us, as we always do. Thank you so much. I'm only going to ask this bill. When you were talking about were you listening to my conversation with the commissioner regarding the written brochure that is given by staff to people at the beginning of the process when there is a concern of harm?
So you were frozen a few times during that, but I think I caught most of that. I caught most of that back and forth with the commissioner. Yes.
Okay. So and I'm sorry I keep freezing. I don't know what's going on, but one of the concerns of the department was that having an attorney there somehow makes people clam up. And when she said that, I mean, I think that did make sense, except as I've been sitting with it, they're having an attorney there that they've asked to join them and that they feel is on their side. So I wonder, how would you feel about a provision of information within that written brochure that stated this is a group of pro bono attorneys who you may wish to have with you if you so desire, give them a call. As simple as that, so people know.
So I did listen. I did hear that part of the conversation, and I think it's a really tricky issue. I do want to echo. I think that the commissioner is right. That, and I am a lawyer, right? And I represented kids involved in the child welfare system, and I participated in every meeting my child client was in. I do think that having a lawyer at the table changes the dynamic. As you know, sometimes it really helps. Sometimes it can make the conversation the department wants to have harder, right? And so and I just say that without placing a value judgment on that. So I heard the commissioner very clearly when she says they want to get in a granular level. In some cases, that's going to be harder with an attorney at the table who thinks the less said, the better, right? And that's true. I think that that's true. That being said, you know, I am a lawyer. I think that, you know, whenever we have to err on the side of notice and due process. It will. I would say that answering these questions on the fly, I do think that I would support having that provision that you are referencing, Representative Linehan, included, and because that is the information. I mean, you know, more is more for parents. You know, if there are resources, then they have a right to know what those resources are, right? And hopefully, you know, the good work the department is trying to do in those meetings will be able to continue. But I do think that parents, you know, should know what legal resources are available to them for a meeting that has such high stakes. The same way as the commissioner referenced, you know, if a child is already in care or involved with the department, I should say, and has an attorney attached to them, because children have a statutory right to counsel in Connecticut when they're involved with DCF, you know, the child's attorney is automatically notified when there's going to be a meeting like that. So, so I would support that.
Excellent. Thank you so much. And I know that my esteemed co-chair will have many other questions for you, so I'll pass them off to him. Senator Anwar.
Thank you, Madam Chair. Thank you, Ms. Egan, for your testimony and a lot of material to digest, if you will. I wanted to ask you a question. There's a little inherent challenge I'm having. You know, with the QPR, from a public health lens, is an early identification tool. and which is critical, and it has to be done. But from a primary prevention point of view, the situations which are leading to the development of the challenges, this new epidemic of children going through suicidal risks, how do we address those? And we probably should have some conversation around that. And then I'd like to seek your guidance on your thoughts on this. Of course, the parts from a public health point of view, opening the state, opening the schools, those are things beyond our capacity. But the things that are in our capacity, Kelly.
Well, that's the question of the day, Senator Anwar, I think, right? Is how do we make our children whole? How do we prevent them from feeling the way so many of them are feeling? And how do we use the dollars that are available to us right now to do that? So I would echo some of what you heard from Representative Flanders, from Attorney Flanders, who's not a member of the General Assembly. That getting children into contact with more bodies that can offer support is a good thing. So that's one way to do that. And two is, helping the school districts who are receiving federal stimulus dollars use those dollars to identify and then partner with their community-based agencies who can support efforts to screen, provide case management, do engagement, do care coordination for higher need families with children. There are municipalities now that have some of those partnerships in place. New Haven being one of them. New Haven Public Schools has some strong partnerships with Clifford Beers. Hartford has some strong partnerships with the Village for Children and Families. But lots of school districts don't have those partnerships. And we have recommended to the State Department of Education and to others that as the plans for how school districts are using their ESSER dollars, the federal stimulus dollars on education, that there be blueprints put out to school districts on how to do those kinds of partnerships for the benefit of their highest need children and families, with a blueprint for sustainability once the federal dollars are no longer there, right? How to use Medicaid to support those kinds of partnerships and other federal and state funding streams. Two, I would go back and, well, I guess it doesn't really get at your question about suicidality, but sometimes it's the low hanging fruit, right? So there's a bill in the Education Committee right now talking about how to sort of compensate educationally for all the things that children haven't gotten. And the bill is very good and has a lot of really good things in it. But it's, I also think about things like, can we send every child to camp this summer? Right? Can we help children? How do we help children have fun this summer? How do we give them a developmentally opportunities to thrive? Can we invest in community mentors, in recreation, in swimming, in Girl Scouts, and and get the money to the community-based grassroots organizations that work directly with families. Sometimes it's not high-tech solutions, sometimes it's low-tech, right? And then probably most importantly is, children who live in families that are struggling to meet, as we know, we talk about this all the time, struggling to meet their basic needs. I don't know what all the limitations are on the federal dollars, but part of me thinks about how much affordable housing can we build as fast as we can with that money, right? So that children don't have to worry or live in a home where their parents are worried about keeping a roof over their head and food. The food insecurity that's going on, it right still is, it's the basic things. It's the basic things, and so that's, I think that we've got to put, we've got kids have to have people to talk to. They have to have places to go have fun. I'd love to see some of the federal education stimulus dollars used to give grants to community-based organizations that support children's play and recreation. Right. So those are just things off the top of my head that we've been talking about, but again, I always think about starting at the early, also thinking about, and I see, Beth By's face smiling at me in the corner of the Zoom meeting here, thinking about our babies and their moms and dads and grandmas, and, born in this incredibly acute and protracted time of challenge and health crisis. and looking at, we have to do a lot of things right on the early childhood side. Can we get more supports to these infants and these toddlers? Get more supports to their parents, get more home visiting out there. I think, those are prevention dollars very, very well spent.
Thank you so much. I think this gives us a little bit more work to do, essentially, from what you're sharing, and I think I appreciate that a lot. My fear is that these federal dollars will be used to balance the budget, and then we will have a cliff that we will have to deal with, and that's what I saw in the governor's budget. And I think we have to just be focusing on what do we do for all the vacuums that we have identified already in our situation. So thank you so much for your testimony, Madam Chair. Back to you.
Thank you so very much, Senator. Representative Foster.
Thank you so much for being with us again today. I always enjoy your testimony, as others have said before. I know that we sort of cover this a little bit with Senator Anwar's questions, but I'd just like to circle back a little bit about your thoughts around the birth to 3, birth to 5 transition. So I am very grateful to have been the beneficiary of their services that have remained excellent and high quality throughout this pandemic. My family has really been so grateful for the continued support. And I think we're likely one of those families that is going to have that cliff that that we've described, where we likely won't qualify for services that we would have otherwise. And I see that this problem exists too from WIC to Head Start. Or from as families enter into Head Start, they're enrolled in WIC for the first time because they have a family resource coordinator, but that didn't exist in prior programs, where they missed the whole pregnancy to 3 before they got into Head Start, where they could have been benefiting from the WIC program. And I wonder if you think that there is an easy fix or solution to that conversation. I mean, I think the birth to 5 transition is, I think there's a compelling case to be made for that. But is there a solution that allows for families who don't qualify for preschools that you think is a good counterbalance to this? You referenced the document. I don't know if I saw that in your testimony, the findings of the report related to that transition. So if you didn't share that with us, I'd love to read it. But could you talk a little bit about that?
Yes, thank you, Representative Foster. So just to be clear, what supports would be available for children aging out of birth to 3 who don't qualify for Part B services?
Right, because I know that if they're aging out and they go into a Head Start, in birth to 3, they ask, do you need nutrition support? And if you do, they enroll you. It's case management, right? They enroll you in WIC. They make sure that you get food and nutrition support. That's all part of their intake and screening. But if you don't get into the birth to 3 system and you don't get into Head Start, then who is making sure that families are also getting every other service that they qualify for, so that they can spend as much time, effort, and energy, mental capacity focusing on being the best parents that they can be for their child, and less worrying about their food running out, or if they've provided healthy food for their child. And so those kinds of questions, I mean, are you familiar with the statistics of, like, what is the difference of families that fall through the crack that are getting one program that should qualify them for another and they're not?
Yeah, those are very good questions. I don't know the answer to all of those questions, but I do know that, one suggestion that I just made before with Senator Anwar is, that's part of the role of home visiting, right? Mm-hmm. So when home visitors are providing a lot of informational support to parents, right, to new parents, and connecting them with the services that are available, which is, and home visiting is a relatively low cost intervention. I mean, I'd probably say a very low cost intervention that's evidence-based for supporting developmental and all kinds of other outcomes for children. And so, one sort of universal way to support families who may be higher need is to scale up the home visiting supports that are funded by, right now, or administered through the Office of Early Childhood. And Connecticut has, as you pointed out, Representative, has tremendous inequities in our birth outcomes for lower income families and children of color, in developmental and health outcomes for infants and toddlers of color, and expanding access to those very early childhood supports, which come with sort of their own case management, as you're talking about, which is so important, is not only essential at improving health and developmental outcomes, but at addressing racial inequities that are very stark in the state of Connecticut as it relates to this very young population.
Thank you. I appreciate you talking about this. I mean, it seems like there's a lot of work that needs to be done when it comes to what we're doing for children. And I think very often in the research space, we talk about the first 100 days and how those are pivotal moments to influence a child's health and well-being, you know, on and on and on. And I think that there's a challenge that we have, that we focus less on prevention, and some of these things don't seem directly correlated with healthcare outcomes, and so we sort of fall, like we deprioritize them. But the conversations, I think, warrant elevation and prioritization over and over and over again, because so many of these things are related to outcomes. So thank you. I know that wasn't a question, so I apologize. But thank you so much for being here with us today and for your testimony.
Thank you, Representative.
Great. Thank you very much, Representative. Are there any other questions? Okay, seeing none, thank you so much for your time. And as always, we will connect and talk about those concerns and issues and see how we can further strengthen this bill in ways that we believe will support the children of Connecticut.
Thank you. Thank you.
Thank you. Okay, next we have Attorney Solimini, followed by Commissioner Bai, and then Tom Nichols.
Hi, this is Lisa Solimini. Can you hear me?
Yes, we can hear you. Please go ahead.
Okay. Sorry, I'm doing this by phone, so I just want to make sure. So I am here today to speak in support of Tristan's Law, House Bill number 6566. I am an attorney, a mother of 4 children, and a small business owner in the state, also longtime friends of Christy and Tyler. So by way of background and just to offer a different perspective, I represent a large local bus company throughout the state, which has enabled me to become familiar with the obviously state regulations and the many, many layers of precautions and due diligence that the bus companies have to operate under to protect children. So when I became aware of this situation, it became very aware to me of the voids in the law concerning ice cream truck safety and regulations, in particular, the lack of uniform practices. Some of them have the stop arms, some of them don't. Any vehicle would have caution lights, but more importantly, that none of them seem to utilize the safety precautions that they do have, which is, of course, alarming, given the level of excitement that usually comes from children when they hear the sign, the jingle from the ice cream trucks. They all start running and grabbing their money. In looking into this a little bit further with my client, it's been sort of determined that the cost of a stop arm is $425. When I think of this in terms of a cost of business, I represent businesses and am not usually in favor of additional restrictions that are going to place an undue burden on a business. This is clearly not one of those situations, because when you factor in the cost of doing business, a one-time fee of $425 or something similar to ensure the safety of your customers, when you're dealing specifically with ice cream trucks, they are targeting minors and children. And as there's a lot of lawyers involved, we all know that children are treated differently under the law because they have a different mental capacity, a different appreciation for danger. So I know there's already a lot of support for this, but I wanted to add the additional perspective that, when you're buying an ice cream truck and your prime customer is going to be, children, I think there's a necessary burden that the law has sort of forgotten about, protecting the children in this instance. And I'm sorry if I'm rambling. I submitted a letter to support all of this as well, but I just wanted to lend my support for this bill and add a different perspective from a business owner. And, this is just the cost of doing business, especially when you're, selling to minors, essentially. Yes.
Yes. Your time is up. If you can summarize in 2 or 3 sentences, thank you.
That's it. I'm sorry.
Well, thank you so much. I know you're on the phone, so I'm going to let you know this is Chairwoman Linehan speaking. I want to thank you so very much for your testimony. And I'm really glad that you are here to talk about what you call the necessary burden of the stop arm. I think, you haven't been you haven't testified in this committee before, but my co-chair and I have made it very clear that the point of this committee is to look at the safety and wellness of children, and that we are not real big fans of people putting small costs in front of the safety of children. And I think that your testimony really spoke to that, and it was very important. So can you tell me the cost of the stop arm? That's really only $425 for school buses?
Yes, and I verified that with my client and also on the internet through Unity is one of the vendors and Midwest Transit. And again, like any accessory, we'll call it, there's, varying degrees of them, but that is what the bus company pays pretty much anytime they need a new stop arm.
And thank you for that, because I think for the benefit of this committee, that's really important. And, you had said that you thought that this was a necessary burden. And, I agree. I think that it's really about being good, what they call corporate citizens, even though these are small businesses. It's just doing the right thing. The safety of children, if those are their customers, it's even more important for them to do the right thing. And I think that your testimony, considering where you are coming from, I think it was extremely beneficial for the members of the committee to hear that. And I want to thank you so very much for bringing that to our attention.
Yeah, and if I can just add one other thing, I mean,
please.
Again, now every time I see an ice cream truck, I look. Most of them, if not all of them, already have the stop arms, but they, in Tristan's case, the stop arm wasn't being used, which
right.
is even more horrifying because, you have another child who, hit Tristan, and a 17-year-old, was able to drive, but maybe not appreciate the dangers of passing a parked ice cream truck. So uniformity in the law, as in addition to the one-time cost of making sure that there's enough proper safety equipment to, add another layer of protection, I think is just as important. But
absolutely. And you're right. For those of us who are very keenly aware of the situation, we really had the loss of a child, and then we also had a tragedy befall another child. They were the driver of the car. And so there are families hurt on all sides. And I keep going back to your words, necessary burden. It just makes so much sense to me. But I want to ask one final question. In this bill, there is the opportunity for 2 separate fines. There could be the fine against a car who passes the stop arm, and then there's the fine against the vendor who fails to utilize it. Would you support fines in both areas?
I would, because I think they're both equally important.
Absolutely. And I think of Tristan all the time. Here I go, getting choked up again. This tragedy rocked my town. And I do think of him all the time. And I have a 7-year-old son who consistently crosses the street before that arm is stopped to get onto the school bus. And I scream at him every single time. But he's 7. And so in my mind, I will keep screaming at him to pay attention to that. But you also brought up a very good point, is that their brains are not developed enough to adequately assess risk. And so therefore, it is really, the onus is on the adult in his life, me to yell and scream at him until he complies, the bus driver to do the same, to put out the arm, and the cars that are in the neighborhood to pay attention to that arm. So I'm in agreement that there needs to be fines on both sides. And in addition, and I have to, please forgive me, because we went through a couple iterations of this bill, and I don't remember which one was ultimately filed, but I do think in order to honor Tristan and his family, there needs to be something contained in this bill that is education related for kids who are starting school in kindergarten and every year through the 6th grade. Would you agree with that?
Absolutely. I think when they're getting the training and everybody learns you have to stop when you see a school bus sign, they should also be aware that, you know, anything in particular, like even food trucks, and in this case, we're specific to ice cream trucks, but, you know, again, an ice cream truck, you can expect kids darting out of any which direction because, you know, they want their ice cream. It's a little bit different.
And there's music playing. You call them. They're saying, come here,
and I'd like,
you know?
And I'd like to pretend that my kids are as excited to go to school, but, you know, they're not usually running and, you know, that excited. So again, I think even, you know, there's a higher risk with ice cream trucks than, you know, the school bus, because the kids could be coming, you know, from any which direction, chasing the ice cream truck down the street, which, you know, we have all seen. So
yes, we have. Well, thank you so much for your testimony. I really appreciate you taking the time out to do this. Are there any questions from members of the committee? Hearing none, you were so thorough. We appreciate you very much. And thank you. And hopefully we'll be able to pass Tristan's law.
Thank you.
Thank you. Have a great day. I'd like to call, please, Commissioner Bai, followed by Tom Nicholas and Robert Goodrich. Commissioner, hi, are you with us?
I am here. Can you hear me?
Yes, we sure can.
Super. Thanks so much for having me. I'm here today to testify on SB2. So good afternoon, Senator Anwar, Representative Linehan, Senator Martin, Representative Dauphins, and distinguished members of the Committee on Children. My name is Beth Bai. I'm here to testify on SB2, an act concerning social equity and health safety of young children. The part of it that I'm here to talk about is the part that asks OEC to implement a plan for the birth to 3 system. And the bill also requires that the parent fees be eliminated for birth to 3. I'm really proud of the birth to 3 program, and I was proud as a parent to participate long before I even thought of running for office or being a commissioner, but it's such a super program. It supports infants and toddlers with developmental delays or diagnosed condition that has a high likelihood of resulting in a delay. The system is part of the IDEA bill, Part C. One of the great things about birth to 3 is that the services typically happen in a natural learning environment for the family and the child, such as the home or the community setting. I heard our child advocate talking about this too. This approach really bolsters natural learning and helps parents know how they can help their children in the natural setting. Birth to 3 really sees parents as a primary provider of services, and their physical therapists and occupational therapists and early interventionists work directly with the parents. Birth to 3 is very popular with parents, and the outcomes for both children and families are very positive. The system offers parents a lot of choices about where it's located, It's centered around the family with the important focus on family engagement. And then when the child turns 3 years of age, if they're qualified to continue to receive services, they move from Part C to Part B, and the families transition to the public school around age 3. Most of the time, those are offered in the public school setting, and most of the time on a part-time basis, so it can be somewhat inconvenient for families. There are some notable exceptions. I know one is the Wintonberry Early Childhood Magnet School in Bloomfield, where children actually get 5 days a week of preschool plus all the services, and everyone's integrated together. This is a real beautiful model. And for families, then their child is always in the same place, et cetera. But that is not typical. The typical is the districts, if the child receives 2 hours of physical therapy, they might go to the public school 2 days a week and get that therapy as part of their preschool program. There's also some challenges in the transition from birth to 3 to the public school. And for that reason, Public Act 19-184 established a working group. Thanks to Representative McCarty, she participated in these meetings and was the legislator who asked for the study. Others were in support too. The report can be found, there's a link in my testimony, but there were 4 recommendations. One is to require screening, the ages and stages screening for students that are found not eligible for Part B, so that the schools can have that information. Another is to encourage all communities to have an early childhood liaison who's helping make those smooth transitions and connections. Consider additional data collection for monitoring children found not eligible for Part B. That was part of the reason for the study, is these families are getting all these great supports and then they turn 3 and they don't qualify for anything. And so it can be a real cliff for families. Also to monitor the collaboration between community-based programs and LEAs. Particularly if children were found not eligible to Part B, to see on the follow-up what happens. And the other was, which we did this year during the pandemic, to allow families that have a child turning 3 from May to August to have the choice to remain in birth to 3 to avoid the multiple transitions before entering schools. This does require additional resources. We were able to use resources last summer for that. At this time, we feel a plan to expand to a birth to 5 system is premature. I think this working group had some really great recommendations, and that's a good place to start. We are really committed to continuing to work on these issues. When a child does turn 3, if they are eligible for Part B, they do transition to the public schools, as I said before. Oh, that's printed twice. Okay. The other thing this bill does is it proposes to eliminate family cost participation fees. These fees were implemented in 2003, and we've been able to waive them again during the pandemic. We're a little bit concerned that there's so many children who weren't referred at this time because they weren't in preschool, they weren't at playgroup. Nobody was saying to a first-time parent, oh, you should have the child evaluated. That there's going to be a spike, and also we don't want, it's hard when the parent fee gets in the way. There are costs to that, and that are not considered in the budget. So anyway, that's about 1.2 million annually, and that is not in the governor's budget. Thank you for letting me testify. I'm happy to answer questions. I think my big point here is, I think as a state and as a country, there's a lot to be proud of in birth to 3 and how it centers family and builds a program around family needs. And so we can understand where this idea comes from. And as Sarah Egan said, we should in the short term, immediately look for ways to have our Part B program have more features of the Part C program. But I know as commissioner, it's always the most popular program I have in my agency. Birth to 3 gets it done. So I understand the sentiment of the bill.
Thank you so very much, Commissioner. Before I hand it over to Senator Anwar, I just have a very quick question.
Sure.
The expansion of birth to 3 to becoming birth to 5, as written, do you believe that federal COVID money coming in could be applied to this?
There's not that much COVID money in the birth to 3 system. I know there was a small amount, but like for childcare, for example, it's, $270 million, so it's a whole lot of funds. Part C is much, much smaller. Like that may help with something like parent fees. And I just had asked my team to look into what are the options for that. But Part C didn't get near the consideration. Now, there could be a way that public schools who got significant appropriations could say, you know what, we want to assign some of those to let Part C continue. And Part C also bills Medicaid, which does leverage some federal dollars. So I think it's beyond the scope of our agency, and our agencies see the new stimulus dollars. I know it's CRRSA is the one we're working on now, but there's a whole new one once it passes the House coming our way.
Right. And so I understand that there may not be a great deal of money earmarked specifically for the Birth to 3 program across the country in that federal legislation, but couldn't it be possible, and I won't hold you to it, but couldn't it be possible that there's money in there that is used for the general purpose of the education or the development of children that we can, as a state, ultimately decide can be funneled to the Birth to 3 or Birth to 5 program?
It's an interesting question. I'd really need to do more research in sort of my broad understanding of the education dollars, because I know, speaking to Commissioner Russell Tucker, a lot of that just goes right out to the towns. And one of the big challenges in Connecticut is that every town wants to do their own thing. And so you may have some towns that buy in and say, oh, I'm going to work with my community-based providers and continue some of this Birth to 3 intervention. And other communities may say, nope. My experience with early childhood special education is that there's not been much innovation in 30 years there in Connecticut. The programs often still run 4 days a week, half a day. As someone who ran a child care program, I'd have a child with autism who's working on their social skills. The bus comes at 11:15 a.m. Now they're missing lunch with their friends. Then they go to the elementary school where they sit in the parking lot for 20 minutes while they wait for the morning class to leave. And then they go in for 2 hours to get their speech OT-PT. And then they get back on the bus and come back after nap time to join their friends, not having had a nap. And I had an experience 2 years ago, because I think I was still in the Senate, so it must have been almost 3 years ago, where a parent who was an attorney had a young child who 2.5 needed speech, turning 3 was 2.5, turning 3 needed speech therapy. And because of the structure of the program, she had to quit her job because she knew this was important intervention. Parents want to give their child what they need. And that's why I mentioned Wintonbury, which is like an integrated early childhood magnet school in Bloomfield, and it has Hartford students too, where the kids just go to school and the specialists come in their classroom and there's no worry. Because the other thing that happens with special ed preschool classrooms is they tend to, by April, be way out of whack. It's like instead of 50-50, it's 70% children with disabilities, because there's a requirement that they are served. So you're on to something, that there's a better way. I don't have the answer. That's why I said it's premature. We need to talk about this. But I will say there has not been innovation in decades, despite all we've learned, because school districts have had so many challenges with their budgets and they just do what they do. But I will say, I think families face huge challenges in trying to adapt to those programs. Like I know in my town, every Wednesday, the special ed preschools close because that's when they do all their IEPs. So understandable, but it's not a model that works for the kids. Now, the same district has opened up 9 full-day classrooms that have children with disabilities in them, and so they're getting there. But overall, I think there needs to be some serious conversation about this, which is what we're having.
Right. And I appreciate that conversation so much. When you bring such a wealth of knowledge, I appreciate you. But I just want to go back for 1 second because you did go out for a minute for me, and I want to make sure I heard it correctly. So I come from Cheshire. We have integrated classrooms here, and I think that's super important. And it's benefited not only the special education child, but also the neurotypical children that would be with. It's benefited everyone. Are you saying, did I hear you right? You said there's only 9 districts that do integrated classrooms?
No, I didn't say that. I will say Cheshire has always been held up as a model because they do have much more integrated. My experience, most school districts, they say they have to be integrated. So they have typical peers, but by March or April, the classroom is dominated by children with disabilities because they're required to serve them. So it's not even 50-50 by mid-year. Now that's not everywhere. Again, districts that have added, like in I'm trying to think, out by Senator Austin, I think that's called, in Eastern Connecticut.
Yep.
A lot of those districts now have universal preschool. That's not typical in Connecticut, but for the districts that have universal preschool, because they don't have enough childcare and preschools out there. So the schools have said, we need this.
Yeah.
They tend to have more integrated special education classrooms without what I'm talking about here, which is the half-day model, 2 days a week, you come here. But most still do not have that fully integrated special education classroom. It's not living up to the goals of Part B overall. And SDE is doing a super job trying to support transition. I'm just saying my experiences, things have not changed a lot.
Right. Thank you so very much for your input on that. And when you said universal preschool, I got the goosebumps. So we can dream and we can work towards that. Absolutely. So thank you so very much, Commissioner. I'm going to now throw it to my co-chair, Senator Anwar.
Thank you, Madam Chair. Thank you, Commissioner, for your testimony. And sorry we had to wait for a little long today.
Oh, no problem. That's we all have to wait.
So Commissioner, I wanted to clarify. So you said birth to 3 are part of the bill is okay, but beyond 3 to 5 is where we will have to go back and look at the recommendations that have been made based on the committee.
Yeah, the committee's made recommendations mostly related to summer funding, so children don't have to go through so many transitions over the summer. But the 3 to 5 part has not been worked out. You know, it's really complex because it's a mix of parent fees, Medicaid, Part B, Part C. I think there needs to be a real planning conversation with State Department of Ed that has really talented staff in this area, and OEC, and frankly, with families. At OEC, we're trying to center the voices of families. So I think there'd need to be, we'd want to do it right. And I think there'd need to be planning and then coming back to the legislature where, again, I think you get community feedback in ways that's really valuable once there's a plan.
And that's probably the area of opportunity for within this bill that we can look at based on.
Yeah.
Okay. Can I ask you for the Child First program, is this, should I talk you offline?
I'm happy, you know, I'd really love to just for a moment clarify, because there's so much misinformation out there about Child First. Child First is one model of home visiting that applies for funding from the Office of Early Childhood as part of a home visiting mix. There are 4, 5, 6 models of home visiting. And we have had an RFP process going. There were concerns from some legislators and others that one particular model, the one you mentioned, would be disadvantaged. And there were concerns about those services being available. We worked with OPM. We adapted the RFP. We extended the deadline to make sure it was clear that there were not models that were being excluded or disadvantaged from an RFP process. OPM and the legislature always want agencies to go out to RFP to say, what are your goals? Go out and have a fair process, which is what we've done. We've gone out, we studied for 2 years, we've had fellows, we've had a process. When there were concerns in that process, we adapted and extended. And all of the applications are in, they've been reviewed, they're in the scoring phase. And all of a sudden, there's this renewed concern. I think as the awards get closer, people who've been providing services get anxious. That's all I can say. But we will have home visiting contracts. We will be serving children prenatally through age 6 with home visiting services. I cannot tell you what models won in the RFP or didn't. I was not on the review committee, but we had a very fair review process. And nothing's been decided at this moment, but it's just hard for me to, like, I just took questions and comments in appropriations when, when you have a process for awarding significant state dollars, there are going to be people who are upset no matter what the proposal looks like, no matter what the results look like, but we are asked to enter into a fair request for proposal based on the state needs, which is what we've done. But no models, not the one you mentioned, not the 4 others, were targeted or disadvantaged. Our job is to provide home visiting. People that have models, their job is, especially they believe in their model, to try to promote their model, and that's all good. But this has been I just want to say so clearly, it's been an incredibly fair process. We took feedback all along the way. Our scorers are not listening to people lobbying for one program or the other. They're scoring on a fair rubric. And that rubric is based on answers and blind answers in an RFP. So our priorities are to address equity, to address some significant challenges in Connecticut around prenatal, perinatal, and early childhood supports that parents need. I was excited to hear Sarah Egan talk about universal home visiting. That's a conversation I think we need to have. And in fact, Senator, as part of our home visiting process, we said, what if we got rid of how we do everything and just did universal home visiting? Would that have a bigger impact in Connecticut? We decided no, that some of these interventions we had and the existing structure was important. But I'm sorry to go on, but it's been a frustration of mine going, that like we are in an RFP process. It's very structured. It's incredibly fair. Everybody knew what we were looking for when we sent out the RFP. Agencies responded with how they could meet the goals of that RFP. And now that is being scored in a neutral way where people don't even know what application has who in it. So I hope I've been clear, but
yeah, no, this is very helpful.
It's been something I haven't quite been able to, I hope that clarifies things.
Yeah, just a quick little follow-up for clarity perspective, and then this is only from the constituents' perspective. Yeah. So there's a group A which has been providing the service to the vulnerable community, and they are not selected, and then another entity is selected. If that happens, there's going to be a lot of shuffling, and we're in the midst of a pandemic where we all recognize that we have a major challenge brewing. That shifting and then moving the personnel and visitors and support system and coordinators would change, and it'll take about 2 months to get that going. That's a little scary that things will fall through the cracks.
Yeah, we've been doing, yeah, I hear you. And we've been doing a lot of transition planning. No matter what, there would be a transition of providers. But I have a lot of faith in our providers and in our process. And, we will certainly be open to input if people think that isn't going well. But I hear you. And we are being very cautious in our planning for a transition. But we don't even know who will or won't get the awards right now. So, I can't say what those transitions will be.
Okay. Thank you so much, Commissioner.
Thank you for giving me a chance and suffering through my trying to explain the RFP, because you always have people saying we need an open process, and then you have one and people are worried that they won't come out on the right side of that process. What we care about, and I think all the providers care about, is that children and families come out with the best possible services. And that's our total focus.
Thank you. Agree with you. Thank you so much. Thank you, Madam Chair.
Thank you very much, Senator. Is there anyone else with a hand raised? I don't see any. Hearing
Okay.
no more questions, Commissioner,
you.
you're all set. You're off the hook.
Thank you.
Thank you so much. Have a great day.
You too. Bye-bye.
Next, I'd like to call please Tom Nicholas, followed by Robert Goodrich and Olivia Rinks. Mr. Nicholas, are you with us?
Yes, I am.
Hello, sir. Welcome to the Committee on Children.
Thanks very much. Good to see you. Can you hear me?
Yes, we can. Go ahead.
Great. So good afternoon, Representative Linehan and Senator Anwar and members of the Committee on Children. My name is Tom Nicholas. I'm the Vice President of the Connecticut Education Association, here to testify on Senate Bill 2, which we have some concerns about. One of the things is that this permits the virtual learning on an ongoing basis with the approval of the State Department of Education. And CEA believes that this proposal would result in, or could result in, great harm and inequities, certainly for school children across the state. While virtual teaching has served its purposes during this time of COVID, remote instruction is not good for the majority of our children. And it is not the ultimate way or the way that we educators want to be able to teach our children. And especially this dual instruction where you have children that are in front of you and children that you're responsible for teaching virtually. It is untenable to provide a great education that way. With regards to the virtual instruction, I would ask that you realize that teachers would need additional planning time. As I said, you're working with kids in front of you, you're working with the kids virtually, and we don't have the necessary planning time that we need. And so going forward, we really would like you to prohibit dual teaching settings. And until we get there, provide more time for planning to help engage and manage these settings. We're very much opposed to that simultaneously teaching both in person and remotely. And I'd also encourage you all to talk to educators about ways that they feel this has been very difficult, because I think a lot of times, you know, the real true story doesn't come out. So when you're dealing with both remote and kids in front of you, you know, the children have deadlines and things that they're supposed to complete, assignments when they're in person, as opposed to being distanced. And the kids who are at a distance don't get assignments in the timelines. It's much more difficult for them because you're not right there with them, you know, looking over what they're doing. So there's a difference in what's going on.
Thank you, Mr. Nicholas. A lot of time has passed. Can you summarize in 2 or 3 sentences, please?
I will do my best. So again, to look at this synchronous learning is just not the way that we need to go. Virtual parent conferences also, you know, it's a good thing, but that is really decided by local entities and the local districts. And you need to take into consideration what they want and also the teachers in that district. And with regards to adverse childhood experiences, I would just like to say I am very encouraged that you're looking at this and looking to adopt certain ways that we can get this. But as the bill is proposed, the ability of people to get these scores and get an understanding of what has happened with this child, to have them in a state of trauma, we don't need to release that to as many people as this bill currently would expose outside entities to getting. Thanks very much for your time. I appreciate it.
Thank you very much. I appreciate your time. I am sure we're going to have quite a few questions for you. I just have two. First, did you submit written testimony that gets deeper into the issues? Because I know it's hard with 3 minutes.
Very hard with 3 minutes, and yes, I did. Thanks.
Okay, great. Thank you. Unfortunately, I do have members of the committee who have been looking for it and can't find it. Would you be kind enough to email that to me when we're done here?
Absolutely.
Thank you. I appreciate it. And then, you know, I'm going to be honest, as a parent, I absolutely hate remote learning. I hate it. And not just because it's difficult on me. I mean, I think it's difficult on my kids, and I understand that's difficult on the teachers, but I can't help but think about the child who doesn't have the ability to go to school right now, those classrooms that are closed, or the parents who are struggling to stay employed yet maybe underemployed and who cannot take time off from work in order to go to a parent-teacher conference. So as much as I absolutely hate distance learning for parents, children, and educators, the truth of the matter is that I still believe that it is necessary when in-person learning isn't possible. And so, we have to really think about that. You're talking about inequities. I think the greater inequity is when a child can't go to school, and that if there isn't an opportunity to be involved in classroom participation and learning. I mean, can you at least agree with that? Maybe it's the kinks we need to work out, but wouldn't you agree that the greater inequity would be not to have distance learning at all for kids who can't go to school?
So there was a lot in there, and I agree with a vast majority of what you were saying. We know kids learn better when they're in a school. Done deal, we know that. But like things that we didn't take into consideration when getting going was, are kids tested at school for COVID? No. There is transmission, but we don't know because we don't test. We don't know because it's not really tracked. There's all those kind of things that we don't know, and kids often don't demonstrate signs of sickness. So my thing has always been, losing one person to COVID because of not really following up on that is not acceptable to me. And the other thing I really want to say with regards to teachers is, I know certainly for myself and the people that I have always worked with, we would meet with parents whenever they want and figure out a time that works for the two of us. I have never known an educator to turn down a parent meeting, personally. So that's just me.
All right. Well, thank you very much. I appreciate your testimony. Senator Anwar.
Thank you, Madam Chair. Thank you, Mr. Nicholas. Mr. Nicholas, when you were initially in the testimony, we could see you, but then I wonder if by mistake you have canceled your camera. Was it by design or by mistake?
Mistake. Sorry.
Okay, good. Good. All right. Thank you. Because I saw you speaking and then I lost you. And if I may clarify, you're representing Connecticut Education?
The Connecticut Education Association, yes.
Okay, good.
We reach more than 1,000 districts.
Yes. I know you guys very well, and then thank you for all the work that you do across the state. I wanted to clarify a couple of things, and then if you could help me understand. For these adverse childhood experiences, is there another bill in the Education Committee around this? Are you aware of?
Not that I'm aware of right now, no. With regards to ACEs?
Yeah.
No,
okay.
Not that I'm aware of.
Now, the thought process was about the ACEs is that, is there an opportunity to expand ACEs, especially with what the children have experienced in the last year, and see if that information would be able to help us place the ever limited resources the state has for the SEL and or other intervention that could be needed based on the nerve center data, if you will?
So I know there is other language with regards to doing screening around COVID in children and the trauma that they've experienced through or from COVID. I can't remember what it is offhand, but I can get that to you. So yes, without certainty, kids have experienced more trauma because of COVID and, you know, not being able to get out and play and do all these things. I think it was Beth Egan who was talking about all those things that, you know, we should be looking at. What can we do with the money that we're getting in the future for our kids, and, you know, getting them out to recreation areas and doing, as I think she called, the soft skills with all our kids. And the SEL learning, those initiatives, we should be pushing so highly, and we need to back away. I'm sorry, but we need to back away of going totally down an academic, you know, mindset. Because we all know if you're not feeling safe and secure, you're not going to learn. You're not in a place where you can do that. So we need to be making sure that our children know we are there for them. We've got their back. We are going to provide the happiest, healthy place that you can possibly be in. And if you ever need something, come and talk to me and tell me what it is that you need. That's what we should be focused on right now.
Right. So as a part of the screening, is there any ACEs-based questionnaire or survey done in school systems at this time?
I've been talking about it. I can't say to you with certainty that I'm aware of a district that does it. I know in, for example, Illinois, they do a lot of it.
But in Connecticut?
I don't know of a district that's using ACEs, the screening score. And one of the things I've said with that is if our local does do that, then all we should get is a number. We should not have in a child's academic folder, in my opinion, all the minutia of what has caused this child's trauma, because that can get out to too many people. Give me, you know, a 9, you know, a 4, a 2. Don't give me all the details.
Yeah, and I don't think that's the intent in the bill, and it doesn't say it that way at all. But I think that the ACE's intent is to have the state board of education be involved in coordinating a questionnaire to help identify some of the high-risk situations or adverse childhood experiences that we can actually look at in an aggregate, not in specific, in aggregate. And what that would do is we can actually have resources allocation accordingly with a specific type of resources that may be needed. I think that's the intent of the bill. Now, one of the earlier conversations we had was that there was a concern raised that, well, if we have ACEs information very deep down into a specific small district, identification of that experience could be connected with the family. And so with that, part of me thinks that that maybe we don't need to have it shared at the district level, but it should be at the nerve center level, if you will. I'm calling the nerve center or the cerebral level at the state education. And then how would you feel if that was how we were planning to achieve the ACEs information?
So with regards to the screening, I think the ACEs inventory does a pretty good job right now of how it's laid out, and it wouldn't be anything that really needs to be developed. With regards to the ACEs scores, I think that would be very beneficial to teachers to just know the score. And for anybody who's planning the groups of kids that come together, because the way it is now in a classroom, you could have, you know, one classroom that has one child with an ACE score of 5 maybe. And then, you know, the class right next door, they have 8 children with scores of 4 or above. And just by management of those 2 classes, you're going to have a very different experiences based on those ACE scores and what comes out as a result of all that trauma. So I guess my question to you then, Senator Anwar, would be, if just the hub was to receive this information, how does it get to the actual practitioner with the child to know, ooh, I need to treat this child with kid gloves because they've had a tremendous background of trauma?
I think the data gathering, when you're looking at the data gathering, which is applicable and accessible to general public, we have to be very cautious. We have to have layers of caution around it. And that's why having that protection is going to be critical. With respect to that specific child, I expect the existing nourishing, caring environment that you alluded to earlier would be able to have that protection in place.
I agree with you.
The other part I wanted to pick your brain, is there like a local expert at the CEA who is an ACEs expert for the state? And you can answer that via email to either me or Representative Linehan later.
Absolutely.
Okay, we would really appreciate it because we obviously recognize the issue and many teachers have suggested that to us. And as we do this, we want to make sure we do the right thing and it would sync with what the CEA would want as well.
Kate Field comes to mind, but I will definitely get back to you.
The other part I wanted to clarify was that the part about the parent-teacher meeting. So some of the parents in some of our districts or even any of the districts, it may be difficult based on them being essential workers to be able to take time off at a time which is safer and fair to the teachers. And only in those circumstances, we wanted to make sure that would be an exception rather than a rule to have the parent-teacher meeting through Zoom. Now, right now, we are living in Zoom world, and we are surviving. I mean, it's a sensory overload, but at the same time, we are surviving. And the thought was that many of the times it is important to have that meeting when there are special circumstances. So we wanted to put something there so that no teacher could in any of the schools say that, well, we can't do it because it's not allowed by the state.
Yeah, I don't see that happening because it's not allowed by the state. And, as I said, I think it needs to be determined specifically in the local because that's how they do everything. But in my experience, I mean, I know for me personally, I've met as early as 5 in the morning till 10 o'clock at night. And I cannot see a teacher saying, no, I'm not going to meet because that's beyond my school day.
So it would just be something in the law that may never have to be used, but at least would have an opportunity if somebody chooses to say that, look, I have that right, if you will. And if suppose, see, not every teacher is as committed as you may be. And then we're looking at a way to make sure that everybody is covered, if you will.
And I think the local districts can take care of handling that part of it.
Okay, I see. And the third part is, I think when you started your testimony, you suggested that the bill was suggesting that we could have a virtual school at any point. That was not the intent. So
I know that's not the intent, but it is left open.
Okay, so we need to clean that up and make sure that we don't have that confusion at all. I think your testimony is very helpful, and I just want to thank you and also the CEA for the work that you guys do for every single day. Thank you.
And back at you, Senator Anwar. We appreciate what you do.
Thank you so very much, Senator. Are there any other questions? Seeing none, thank you, Mr. Nicholas. We appreciate your time today.
Thank you, Representative Linehan. And I wanted to say that that comment goes for you as well. Really appreciate the work that you're doing.
Thank you, and you as well.
Thanks so much. Have a great day.
Have a wonderful day.
Bye-bye.
Next, we have Robert Goodrich, fellow Sacred Heart High School alum, class of '93, followed by Olivia Rinks and Severa Gordon. Mr. Goodrich, how are you?
I'm well, Representative Linehan. I'm well, thank you. And this is my son, Caden Juno.
It's beautiful. And welcome to the committee with a baby. We always celebrate that because it is the Children's Committee. So it's so nice to see you again.
Right. Thank you. I should start. So I appreciate your warm welcome. Co-chair Senator Anwar and Representative Linehan and esteemed members of the committee. My name is Robbie Goodrich. I'm the Executive Director of Race and a member of the Coalition for Equity and Learning here in Connecticut. And we support SB2 because addressing racial equity, health, and safety of children is a top priority of our organization, coalition, and as a father, I understand how these intersect with our education systems. Now, I want to spend some time with my testimony. I've written testimony, I hope you all refer to it, and tell the story of our coalition, which has conducted an exhaustive process here over the last year, and where we have met with teachers, parents, students, as well as equity and advocacy experts on a monthly basis, and even met with the State Department of Education many times, and have been able to share our experiences, expertise, and recommendations. Now, our brief submitted to this committee and to the State Department of Education makes clear our concerns, and they are establishing a sense of urgency, standardizing a definition of engagement, and applying an assessment of data to student engagement, along with mitigation strategies and accountability measures for student engagement. Now, what's really important here about our coalition is that we also believe now that it's time for there to be a legislative remedy to ensure that student engagement is prioritized as much or more than attendance. That's why we're recommending that an amendment to this bill that will strengthen it immensely. Now, currently, Section 20 does not contain a definition of student engagement, and it also doesn't require student engagement data to be collected. So we believe that the bill must include a definition and call for the creation of a system of qualitative methods to be designed and implemented by the State Department of Education so that student engagement data can be collected and used to increase the safety and welfare of students, especially Black and Brown students in our schools and our communities. Now, I'd also like to highlight that the State Department of Education has been proven to be a reliable and dedicated partner in providing guidance to districts. But what's really important for this committee to understand is that the State Department of Education applied for a waiver that literally pauses many parts of Section 20 in terms of reliably reporting back and using for accountability measures within the Next Gen accountability system, including the metric for chronic absenteeism. So at this point, I'd like to open up for some questions from the committee, but also to read our brief and also to look back at this moment and reconsider amending this bill so that it can go forward and have the impact that the intent that it was originally written with.
Thank you very much, Mr. Goodrich. And did you include the brief with your testimony today?
One of my colleagues has, so either Tanis Klingler or one of the other teachers that are registered to testify today. So
fantastic. Thank you so much, because we will be sure to look at that. I can tell you of all the committees that I hear from our membership often who goes through the testimony with a fine-tooth comb. So I believe you will be well represented here. Senator Anwar, do you have questions for Mr. Goodrich?
Thank you, Madam Chair. Thank you, Mr. Goodrich, for your testimony. And how do you have such a well-behaved son?
Oh, I'm just an excellent father. No, I'm just, he was just fed by his mother. So that's the reason why here remote, right? We're working both remote. We get to share this moment with our son as much as possible. So we hand off in between meetings. And I just got the time when he was when he was not hungry.
And I love the way your testimony comes in and out, and we can see you and see the specific information you're sharing. I wanted to ask you, I've heard the term student engagement data. Could you tell me a little bit more about what that means, and are you equating it with the adverse child? I'm trying to put.
So you cut out a little bit there, but I think I can answer the question.
Student engagement.
I think that, right. So when we talk about ACEs, and the collection of qualitative data that the State Department of Education and districts do. That's one of the biggest flaws within the Next Gen accountability system and the way that districts practice collecting information on student experience. There isn't a uniformed approach, and ACEs is a well thought out course of action to determine what type of resources students need. Now, student engagement is conflated a lot with student attendance. So when we define student engagement as students who participate in 75% or more of learning opportunities, in-person, hybrid, or remote, by signing into lessons and completing assignments and participating in learning tasks. So engagement is measured by student participation and output. That's really important in terms of how we are able to combine the information that we get, say for like an ACEs score, and whether or not the student's academic achievement matches their engagement levels. And that's when we talk about producing 360-degree comprehensive responses to students, no matter where they lie in terms of the spectrum of ability, performance, or identity.
That's helpful. So is there a standardized student engagement data that is available with the virtual world?
No. So this is the guidance the State Department of Education has given to districts is that they're no longer just to sort of measure whether they sign in, because the attendance legislation only requires 50% of a day to be counted as a full day. So a student could literally just sign on for 2.5 hours and be counted as attended a school day. Okay. Now, they're refusing to define student engagement. So the first and foremost is that they need to be able to define it. And then from that point on, they can go ahead and prepare methods to measure it. And then what that will lead to are responsive interventions. And this is really important. Senator Doug McCory mentioned this in the hearing that we presented the same information to in the Education Committee, is that it's the same students, and primarily students of identities who are Black or Brown, Latinx, and disabled, that were disengaged before COVID, but those things were heightened or made greater during the pandemic. So this is just not a COVID fix, but this is a fix that will actually apply to the teaching and learning environments that exist once we go back to school. But the State Department doesn't have a metric right now. So this is innovative, it's new, it's a well thought out idea that we have that isn't necessarily being embraced by the State Department of Education right now.
Okay, I jinxed you, by the way. I also, so I want to learn more about it, but I think what I gathered from your testimony is that we look at ACEs, but we look at the student education data, engagement data as well. To be comprehensive.
Yes, that would be a part of it. It certainly could be a part of it. It would be easy to apply those same type of scores to student engagement and then make those a part of the algorithm that measures whether or not students are actually engaged. It's a perfect qualitative metric to include in student engagement.
Okay, this is very helpful. I'm learning like a sponge right now. So we're getting all the data. Thank you so much. Thank you, Madam Chair.
You're very welcome. I appreciate all your questions and answers. Are there any other questions? Seeing none, thank you. I'm going to call for Olivia Rinks, followed by Sabira Gordon, and then hand the reins over to my vice chair for just a moment, Representative Wielander, and of course, Senator Anwar. Thank you.
Is Olivia available? No, Olivia is here. Well, if she is able to join us later, we will swing back. So the next speaker we have is Sabira Gordon, followed by Christopher Trombley and Christy Carana.
Hi, good afternoon. Good afternoon, Senator. Good afternoon, Co-Chair Senator Anwar and Representative Linehan, and Ranking Member Senator Martin and Representative DeFinius. My name is Sabira Gordon, and I'm the Executive Director of CONCAN. Much of the conversation regarding education is about getting back to normal. We want schools to reopen, restart athletics, re-engage in extracurricular activities. So our goals center on using resources and time to mitigate the issues caused by COVID and to start up again. What if, instead of focusing on going back to what was, we take this opportunity to reimagine an education model that is more flexible,
more supportive, and more equitable. And I just want to mention that working parents, poor working parents, have been hardest hit by the pandemic. COVID has had an impact on communities of color that far outweigh the impact of those of their peers, and working poor parents are really struggling to get by. Connecticut suffers from one of the largest opportunity gaps in America. Our Black and Brown students, English language learners, and students with disabilities face systemic barriers to their success, often overcoming hurdles to achieve the equal results compared to their English-speaking, non-disabled white peers. Now is the time to make significant investments in our schools to dramatically reduce our opportunity gaps and achieve greater outcomes for all students, regardless of their background. First, I just want to talk a little bit about Senate Bill 2. It outlines the role of adverse childhood experience screenings for young people. This work is essential in understanding the levels of trauma as a child who has experienced, by understanding the level of trauma a child has experienced and the necessary resources a district must provide to a school with high concentration of children facing trauma. With this knowledge, we can create a more supportive understanding and responsive educational environment for our students. Next, this legislation also alters important language regarding social and emotional learning and mental health awareness. This year has been the most challenging for young people. I'm a parent of two small kids, a 9-year-old and a 3-year-old, and I definitely can say that has been. The kids had to rapidly change their lives, learning from home rather than school, seeing family members virtually, and having gatherings all happen over a computer screen rather than in person. And for some families, they experienced loss and financial hardship for which our students had a front row seat for. While we commend the work of the committee on this legislation, there are a few areas for improvement. Mr. Goodrich made mention of some of the things that I wanted to talk about, so I'll just skip to. This bill focuses primarily on attendance versus excused versus unexcused absences. We know that that measuring attendance alone is an insufficient marker for how students are engaged. And he spoke a lot about student engagement and why that matters. But I think specifically in many of our districts, students are showing up.
Excuse me, Ms. Gordon, your allotted time is up. If you can summarize in 2 or 3 sentences.
Yes. So finally, SB 2 leaves out the necessary investments we must make in order for us to recover from this pandemic. And we have done a survey of a number of families in Connecticut, and they have mentioned the need for social and emotional supports and academic interventions as some of the things that they really think are going to be critical in moving forward. I also want to commend the committee for really thinking about language around social and emotional learning and mental health awareness, as this is incredibly important for our communities as we move forward. Thank you.
Thank you. Thank you so much for your testimony. When we're talking about engagement versus attendance, sometimes that is a very hard aspect to quantify, because some people's engagement is very different. Do you have any thoughts on how that would be measured?
So I think one of the things, so I can speak from the experience of being a mom and kind of watching how my son engages in his remote learning. He's been mostly in person, but we've had experiences where he's been home for when there's been exposure in the classroom. I think, and I've also seen how other districts do it. I know in some school districts, students do not have to have their camera on when they're remote, and they essentially can be on mute the whole time. I think the idea of having students participate throughout the day is incredibly important. I also think that a student can show up and just be there and not be engaged, which I think as a great educator, I'm very fortunate to have my son have really good educators. I think an educator can look and recognize when a student is there or when the student is not participating in a meaningful way. And I don't think this is something that we look at a standardized way to measure, but it should be a way that we are working with our educators and working with our schools to figure out what are the best ways to see if students are engaged. Are they participating? Are they turning things in on time? I think even if you go back to the idea of attendance, in some districts, being on and whether you have your camera on or not counts as being there or not. I think in our experience, if you're not on camera without an excuse, you are considered as not being engaged in the classroom. So I think there's a lot of ways that we can think about how we could measure that.
Sort of looking at best practices rather than.
Correct.
Yeah. Okay. Thank you very much. Senator Anwar, do you have any comments or questions?
Thank you, Madam Chair. Thank you, Ms. Gordon, for your work and your organization's work. I have had the opportunity to learn about the work for recruitment of teachers and especially in some districts to improve outcomes with students. I wanted to just brainstorm with you a little bit. I think the optimistic person in me wants to look at a strategy, because by the time we'll be done with the session, it'll be June. And my hope is by that time, with enough vaccination, enough protection, we will be moving towards in-person school, and Zoom would hopefully be a thing of the past for the most part. Mm-hmm. If that's the hope, then I do not want to invest too much on the current times, because that legislation will be out of date the moment it's signed. And then for the student engagement, I want to try and hope that the legislation will be more focused on the post-pandemic time, where we are looking at what negative impact the pandemic has had on the children, and then also look at the engagement and getting them back in the picture. I think that's the vision, and if I look at the student engagement, I wanted to look at it from that lens. Is that a fair way to look at it, do you think? Or
yes, I think that's a wonderful way of looking at it, Senator. And I think by connecting the adverse childhood experiences, I think coming out of COVID, it would be, I think it's very likely to think that many students who probably didn't have a high A score pre-COVID would come back with having a high A score. And I think that's where you have to think about the partnership with parents and the educators and schools. I think, and I mentioned that, working poor parents are hardest hit by the pandemic, but at the end of the day, I think everyone wants to make sure that this is a collaborative process moving forward. We don't want to put more hurdles on for parents, but we also want to figure out how to meet parents where they are. And I think I can speak to the opposite side of the gentleman who spoke about teachers going above and beyond. I think there are some places where educators are really stepping up, and then there are other places where there is room for improvement, where parents are struggling to put food on the table and also not being able to figure out how to turn the computer on for their kid, or being able to work through the packets that they had. So as far as coming back to the post-pandemic world, I talked about we should really be thinking about how we can collaborate with community and with family to figure out what do students need. The social and emotional needs of students are going to be greater than anything I think we've faced coming in. I think the need for doing accurate assessments early on, like, is there a way for educators to have, I like the idea of having meeting parents where they are with the having parent teachers conferences be online, but going back into the 2021-2022 school year, I think we need to think about having a counseling session with an educator and parents, and figuring out what if any trauma has your student faced before going back into the classroom, and how can we collectively make sure that we're not having triggers happen within the class, and ensuring that there are best practices being implemented throughout the school day to ensure that everyone's feeling safe and secure when they return to school.
Another angle that we have not necessarily assessed is if there is a blessing in this pandemic, one of them would be that the families have been together. The parents have been in the same house and the children have been in the same house, and suddenly there will be a change when everybody will be gone and there will be an empty home. And so that may actually have a reflex impact on the children. So again, I'm worried about changes that are happening in a very high stress situation to moving towards a different situation, which may not have enough support system. So we will have a tough time in either direction. So for the SEL, are you aware of programs where the teacher training has been very effective and efficient manner for SEL?
off the top of my head, but I can get back to you with information. I know some other states, I want to say it's not that we always use Florida as a high bar, but I think that there's some things happening in Florida around connecting adverse childhood experiences with social and emotional learning. And I do know in California, there has been, I know they do ACE screens in every single, I think they do ACE screenings in school, and it's also connected to social and emotional learning as well. So I'll get back to you with that information. I'll share it with the committee.
Thank you so much, Ms. Gordon. Thank you, Madam Chair.
Thank you, Senator. Are there any other questions from members of the committee? Seeing none. Thank you, Ms. Gordon, for your time today and for sharing this information.
Thank you.
Good to see you. Next up, we have Christopher Trombley, followed by Christy Carano and Rob Dunn. Mr. Trombley?
Good afternoon. My name is Christopher Trombley. I serve on the faculty of the Department of Educational Leadership and Policy Studies at Southern Connecticut State. Additionally, I serve on the Board of Directors of Connecticut CASA, an organization that prepares and supervises court-appointed special advocates for abused and neglected children and adolescents who are involved with the Superior Court of Juvenile Matters. I also serve on the Board of Directors of Connecticut ASCD, the state affiliate of ASCD, formerly the Association for Supervision and Curriculum Development, which spearheaded the Whole Child Initiative nearly a decade and a half ago. I appear before you today to voice my support for Senate Bill 2. It's become commonplace for people to cite the pandemic as having shown a bright light on the needs of so many children and families across the nation and Connecticut. Commonplace, but no less accurate. The pandemic has also served to illuminate precisely how over-reliant upon schools and educators, government at all levels, has become in meeting the needs of families. Policymakers have, as I've written elsewhere, educationalized our nation's most insidious social problems, placing responsibility for solving them on our schools and educators, all while equipping them with too few resources with which to undertake that work. The merits of Senate Bill 2 are many. Among them are its recognition of the importance of ongoing, job-embedded, high-quality professional development for educators, its identification of students' social and emotional needs as an area in which educators require opportunities to acquire greater competence and deeper confidence, its emphasis on enhancing communication and strengthening relationships between educators and families and students, its provision to educators with compendia of supports and services to share with families who are in need of them, and the establishment of a much needed task force to assess the needs of children and the degree to which the state's various agencies and organizations are or are not yet helping to meet them. If all of Connecticut's children are to come to school ready to be engaged, supported, and challenged in their learning by the educators who love and serve them, their families and neighborhoods must first be afforded the ability to help them to be healthy and safe. This legislation presents a major step toward making that a reality. No less important, though, will be the General Assembly's and Governor's ongoing commitments to ensuring enhanced funding for the many worthwhile provisions of this bill and other measures pertaining to children and families, as well as to the state schools. Thank you for your time.
Thank you, Mr. Trombley, for your time and for submitting this testimony and being with us today. Are there any questions from members of the committee? You're all set. Senator Anwar, you're all set? Okay, thank you. All right, thank you so much for your time. We really appreciate you being here today and sharing your thoughts. Okay, next up we have Christy Carano, followed by Rob Dunn and Tanis Klinger. Ms. Carano, hi, welcome to the committee. Oh, you're on mute.
I apologize. Sorry about that.
No, not at all. Welcome.
So thank you, leaders and members of the Committee on Children. As some of you may know, I've been reaching out a lot. You may know me or my son's story. We tragically lost our son, Tristan, on, so I'm here to speak on House Bill number 6566. Which is ice cream truck legislation. And like I said, I've been reaching out a lot. So a lot of you may already know my story or my son's story, which is that we lost our son Tristan on June 12th when he was struck by a passing motor vehicle after having purchased an ice cream from an ice cream truck. And if I go over, I apologize. Just interrupt me. I'm sorry. I think the facts are important in light of the legislation that we're requesting. So on June 12th, it was my son's dad's birthday. It was also the last day of school, and our friends hosted a backyard celebration for the kids. And as we finished dinner and we're putting out our trays of desserts, a whole table full, we heard the ice cream truck in the background, and the kids started going nuts and, you know, begging for money. And I remember talking with our friends in the backyard saying, can we just say no? Like, we have all this stuff. Can we just say no? But the lure of an ice cream truck is too strong, and the kids' excitement was too great. And of course, in their, you know, frenzy, we gave them money, and they ran out to the front yard to flag down or wave down the ice cream truck. And all of the dads went to the front of the house while the moms, for the most part, stayed in back. The next thing I knew, my daughter ran to the back and was screaming, "Call 911. Tristan's been hit by a car." And I just remember running to the front of the house. What ultimately happened was, as our son, who was the first to purchase his ice cream, which was his favorite thing of all time, ice cream for dessert, like almost every night, you'd get a little dessert. He was crossing the street back, and let me back up for a second. I'm so sorry. A group of children, 9 of our children, crossed together while the dads watched the kids cross the street. Most of the kids were older, 13, 12. Our son was going to be 11 and 2 months. So we had 13, 12, 11-year-olds, a couple of 10-year-olds. They all crossed together, 9 kids across the street. There were 0 kids on the side of the street that the ice cream truck parked, and 9 kids on our side of the street that had to cross the street in order to purchase their ice cream. So my son was the first to purchase his ice cream, and as he crossed in front of the truck, and there's no line of sight, because the ice cream truck blocks his vision of approaching traffic, right? And it blocks the driver's vision of children crossing in front of the truck because the truck is large. As he crossed and the car approached at approximately 40 miles per hour and went around the ice cream truck without slowing, as per the witnesses, my husband screamed to our son, as did one of our friends, "Tristan, Tristan, stop." And he either didn't hear because he was too preoccupied with his ice cream, or he just didn't hear, or whatever, he didn't perceive the danger because he was at the double yellow line and didn't see traffic coming in the opposite direction. Whatever the case may be, he was basically crushed. Like, he was gone by the time I got to the front of the house. And I just held him as our world shattered before us. And I'm sure the child that struck him, his world was shattered. He was sick at the scene, completely distraught. All of our worlds were shattered. And the legislation before you today.
Mrs. Carano?
Yeah.
I apologize. I'm sorry for your loss. Your time allotted is up. If you can please summarize in 2 or 3 sentences. Thank you.
Yeah, so the legislation before you today helps to prevent such a senseless tragedy from happening to a child, from a passing driver, from a ice cream truck vendor, for all of the parties involved by requiring safety equipment that actually has been by recommendation since the 1970s and has been adopted by New Jersey, these recommendations, since the 1970s. Connecticut is very much behind the times, and we need to catch up, and we need to protect our children. I would just like to add briefly, in addition to the legislation proposed before you, I would like to add the language of the currently existing Hartford ordinance that would require ice cream truck vendors, or prohibit ice cream truck vendors, I should say, from vending to children that must cross the street in order to purchase the ice cream from the ice cream truck. This ordinance has also been in effect since the 1970s. It is not adopted across Connecticut, although there is absolutely no reason in the world it should not be. In our case, like I had said, there were 9 kids that had to cross the street and 0 kids on the other side of the street. This is a common sense, no cost. There is absolutely no reason to implement that portion of the legislation along with the other safety mechanisms that are proposed before you. Thank you so much for your time and consideration. And I just implore you with everything I have in me to get this passed so other families and across the board don't have to suffer this type of loss.
Thank you so much, Mrs. Carano, for being here. I'm so very sorry for your loss. I'm going to turn the meeting back over to my chair, Rep. Linehan.
Thank you very much, Rep. Wielander. Mrs. Carano, thank you so much for being here today. I have had the pleasure of working with you on this legislation, and I can say wholeheartedly, I wish there wasn't a need for it. I am so sorry for your loss. It has been the loss of an entire community. And I'm honored to be the representative for that community and say to you that we are working to do everything we can to ensure that this doesn't happen to another child. And I apologize, but your family and your story has meant so much to me over the past few months. Because I do see my family in yours. So I apologize that I'm getting so upset, but I believe this is not the first time that we've cried together. So I want to thank you for being so strong and coming forward with this legislation. Let's get down to kind of the nitty-gritty of it. Earlier this summer, we worked together and together we received information from Connecticut Children's Medical Center, and they have a special unit that is devoted to ensuring that accidents like this and preventable accidents of children, that there is legislation that we could do to make sure that that children don't get hurt, especially not out running, playing, and trying to get ice cream. And so for the benefit of the members of this committee, do you remember receiving that information that I sent you from Connecticut Children's? And isn't part of this legislation the recommendations that came from Connecticut Children's?
So yes, thank you. I do remember you sending me some articles from Connecticut Children's, and I did read through those, and some of them were like highway safety articles, research articles that had been done, and I very much appreciated that. But I'm not sure that it's actually part of this proposed legislation, as opposed to the model New Jersey, or the New Jersey law that was modeled after the National Highway Safety Administration recommendations back in the 1970s. So yes, those articles are certainly informative in that they highlight that these incidents are not just in Connecticut, but there are across our nation, across our whole entire nation. And I've done independent research as well. And if you look at the case law in every state across the United States, there are some case that is highlighted in Superior Court, or the Appellate Court, or the Supreme Court that has to do with the death or significant injury of a child as a result of having purchased an ice cream from an ice cream truck. It's devastating. So anyway, yes, those were helpful. I don't want to say that they are a model for the law that we are proposing, but they were certainly helpful, and we are modeled after, I think, the New Jersey law.
Right. And perhaps you're just not remembering, but that information given from the Connecticut Children's, well, it did include some articles on that. It also did include laws and ordinances around the country, including New Jersey, which was what the impetus of what we're looking at here in the legislature, that we want to implement those things, those safety precautions that are in fact in other states and are actually data driven. So the reason why I want to mention that for the benefit of my committee members is this is such an emotional issue. And as is evidenced by my reaction, by your reaction, and I can see the faces of my colleagues who I can see are just as touched by this. But we have to remember that in this committee and in all committees in the legislature, what we do is backed by data. So I wanted, for the benefit of the committee members, to understand that this bill is written with data in mind, and that we're not writing a bill simply because we are hurting inside. We're writing a bill because there is real evidence that these safety measures work. And so we can actually provide that for everyone. And that data that I gave you was actually part of what was used for the OLR report that has been, I believe, utilized for part of the bill and spoken about by other people testifying here in the committee. So I just wanted everyone to understand, ma'am, that you're not simply, and I hate to use the word simply, but you're not just a mom here talking about things that you want to see changed. You're actually talking about real actionable changes that are data driven that can stop this from happening to other kids.
Thank you so very much. Yeah, I am a mom, and obviously the impetus or the catalyst action is my son and wanting to prevent any other family from having to go through this senseless tragedy. And I do have the research. I printed it all out. It's all in binders. I have absolutely every piece of everything before me that was provided by you and Representative Fishbein and all of the wonderful representatives and senators who have stepped up in representation of this law or in furtherance of it. I would just say that I think that this particular law is modeled after, and I just think that we have to be clear in terms of legislative history, that it's modeled after the New Jersey counterpart in most part, and the additional request is to add that Hartford ordinance component that prohibits the vendors from soliciting children to cross the street.
Right, and I asked a person who testified in favor of the bill earlier that there are two opportunities here, and I know that one iteration of this bill had them and another one didn't. So I just want to see how you feel on which one we should pass out of committee. There are two opportunities here for fines to be levied, and that would be one on the vendor who does not utilize the arm when vending on a road. And there is also for the passing motorist. Would you think that fines should be levied in both those cases?
So you'll have to forgive my ignorance, because I think that in speaking with some other senators from the judiciary and also representatives, I'm not sure, and again, forgive my ignorance, if there is a difference between a fine and a infraction, or a penalty and an infraction. And I think that the way the law came from the LCO is that they are indicating that it's an infraction. And my position would be that I want to have some sort of consequence, but the least onerous consequence, that we have the most support of this going forward. Because the most important thing is that everybody is on board to get something strong and powerful in place to curb the actions of the passing drivers. Again, in this case, it was a young teenage boy who didn't appreciate the dangers. The ice cream truck driver who had no guidance, no law in place to help him vend safely to children. I just want something that is going to be supported by Democrats and Republicans and senators and representatives, that we can all get behind and get passed immediately.
Yeah, well, now you're starting to sound like me. You know, and we've had that discussion. But, you know, I think that you have made an indelible mark here on this committee. And there's going to be a lot of discussion about the best bill that we can pass out to make the biggest difference with the most support. And we are doing that in conjunction with the Transportation Committee. So laws should not be made in a vacuum. So we are talking with everyone, like I said before, from Transportation and also from the Judiciary Committee. And we're going to pass out a bill that everyone's on board with. We do want to see change happen. So thank you so very much for being here. This is a very top priority for me, and it will continue to be. So
thank you so very much to everyone. And if you have any questions for me, you can quiz me on my knowledge of this law, or I am here to address any questions or concerns, and to be your researcher for any questions that I can't answer. So please, by all means, ask away.
Absolutely. Well, then let's open it up to the committee. Are there any questions for Mrs. Carano? Well, I think you did. Oh, Senator Anwar.
Thank you. I don't have a question. I just have a comment. Ms. Carano, thank you for your selflessness and reliving a fraction of the pain, because the pain is very significant, but sharing the story just so that you can save other children is one of the most selfless things you're doing, and we can't thank you enough. And we'll make sure as individuals and collectively we do the right thing. Thank you so much.
Thank you so very much for your comments. And I just want to go quick blib. My son was the most selfless, appreciative, thankful, giving boy in his school. They had to pay to dress down. They had to pay to be out of uniform. They had to pay $1 every time they wanted to be out of uniform for a charitable cause. He would try to get $50 from his piggy bank to give to the cause and say, they need it more than I do. And I said, Tristan, nobody would expect a 10-year-old boy to give $50. And he would say, but Mom, they need it. He was different, and I was proud of him every day. And I can only hope to make him proud of me and to have something positive done in his passing.
Thank you. I know through this bill and then through the awareness, you will be saving a lot of lives.
Thank you.
You will make him proud.
Thank you.
Thank you very much, Senator. Representative Wielander.
Hi again, Ms. Carano. I just want to echo what has already been said, and just thanking you for sharing this moment with us, so we can all help to save more children. And I also just want to say thank you for sharing that little bit about Tristan and about who he was, and allowing us to know him through you, and just that little moment. He sounds like a very sweet and remarkable young man.
Amazing. Thank you so much.
You're welcome.
Thank you, Senator Martin.
Thank you, Madam Chair. Christy, thank you so much for coming and testify. Thank you for showing us courage and strength. And I'm sure your son is has a big smile on his face and very proud of you today. Thank you.
Thank you so much. I hope so.
Thank you, Senator Martin. Mrs. Carano, I can absolutely say for sure that he is very proud of the work that you are doing in his honor and in his name. And we do have Father Romans who is testifying in a short while, and I'm sure we're going to hear even more stories about what a wonderful boy Tristan was. So
he was. Thank you so much.
Thank you for being here today, and I will be in touch with you shortly.
Thank you.
Thank you. We'd like to call, please, Rob Dunn, followed by Candace Klinger and Sarah McInnes. Mr. Dunn, are you with us? Okay. Moving on to Candace Klinger from the Coalition for Equity in Learning. Hi, are you with us?
I am with you. I'm sorry, that's the first I've heard of Tristan, and it's a very heavy story. So thank you all for the work you do, and thank you, Ms. Carano, for what you do as well. Okay. Co-chairs Representative Linehan and Senator Anwar, and distinguished members of the Committee on Children. My name is Tannis Klingler. I'm a resident of Bridgeport, a former Connecticut public school teacher, and a member of the Coalition for Equity in Learning. I'm here to tell you a little bit more about our coalition and what we've been working on. We're a community-driven coalition fighting to bring equity and learning across Connecticut so that every child has access to a high-quality education. Today, I'm here to testify in support of SB 2 with a proposed amendment. I did not submit written testimony, but I did email the co-chairs a copy of our student engagement brief for your reference, and I'll say a little bit more about that at the end. Our coalition is made up of teachers, parents, grandparents, organizations, community organizers, and community members who care deeply about the students in Connecticut. Back when the pandemic hit, this group came together when we noticed that our students in the state's largest districts, predominantly Black and Brown children, were not getting the same quality of education as their neighbors. In surrounding affluent suburbs, students were able to go back to learning in days, and our students were filling out packets for weeks. And some students didn't get to be with their teachers or be in a virtual classroom setting for the remainder of the 2019-2020 school year. And I was one of those teachers who was in the virtual setting and transitioned.
Leaders and members.
Okay, and I saw this with my students when I was teaching in New Haven last year. One of the key issues that our coalition has been tackling in this school year is the difference between attendance and engagement. We noticed this when school leaders, district leaders, and our own Department of Education were conflating the terms engagement and attendance. Officially, the state is only held accountable to attendance, and our coalition asserts that this is not enough. We have been meeting weekly as a coalition and monthly with the CSDE to rectify this and to do something about it. We're so grateful for SB 2 focusing explicitly on equity and racial equity and taking a comprehensive approach to children's well-being. We are worried that the intentions of the bill will not be able to effectively direct the services and attention where most needed if engagement is not clearly defined and data is not collected to respond with resources and strategies to re-engage our students so that they have access to a high-quality education. Yesterday, one of the teachers in our coalition testified in front of the Education Committee, and I quote, "A lot of times students are not showing up, not due to their motivation, but due to what they don't have in their resources." Another member of our coalition who testified yesterday is a parent and educator in Hartford. She shared that when her school started to measure engagement and report to parents and families that engagement in her classroom increased. Saida's seeing her students grow 1 to 3 reading levels as measured by their last step assessment. What we measure is what we value. It's not enough to want kids to be in the classroom with their teachers. We need students engaged in their learning. And if they're not engaged, be curious about figuring out why and what a student needs, and ensuring that they have the greatest access to a high quality education. Our coalition
Mrs. Klinger?
Yep.
Your allotted time is up. If you can please summarize in 2 or 3 sentences. Thank you.
So in our student engagement brief that we've put together, we have a definition for engagement. We've put together through listening sessions, how teachers want resources utilized, and how mitigation, like what's mitigation strategies to use to engage students, and possible mechanisms for how to collect this engagement data. I'm available for any questions, but we do invite anyone that wants to meet with our coalition. We would love to talk in more detail, share more, and hear, have a conversation of how we can work together on amending this bill.
Thank you very much. I very much appreciate your testimony, and I look forward to looking at that brief. Senator Anwar.
Madam Chair, thank you for your email in advance. I've not had a chance to look at it, but I just saw it and I'm going to read it quickly. And I've sent it to Peter to share it with the rest of the committee. So make sure everybody has the opportunity to read it as well. Ms. Klinger, tell me, this engagement data, has this been verified? What kind of background research has been done on it, on this student engagement?
Well, what we've learned from our meetings with the State Department of Education is that one of the reasons they're hesitant for us to even start tracking this is other states aren't doing it. So I think because we do not have a uniform definition, we're not collecting aligned data to that, which eliminates the opportunity to really have a data-driven solution and figuring out the value of this. The reason that we're going after it is because these definitions are getting conflated, especially in this time. And what Robert Goodrich shared earlier is that even the Department of Education has acknowledged that our data isn't good enough to report right now because people are using all these different definitions. So because of virtual learning and asynchronous learning, it's actually shifted a lot more towards student outputs. Not just, what are teachers doing, but it's about the outputs from the student in their, are they accessing the education and putting themselves on the best path to actually acquiring a high quality education in the work that they're doing and the ways that they're thinking about content and practicing skills. Does that address your question sufficiently?
It does. And earlier in one of the testimonies, I made a comment that one of the thoughts is that should we be strategizing for beyond this pandemic and in this bill, and were you able to hear my comments? And would you be able to reflect if you heard them?
I didn't hear the full comment, but can I respond to what you're proposing? Or you can expand further.
Yeah, let me actually tell you.
Please.
But the thought was that by the time this bill hopefully will become a law, it will be somewhere in June. And I'm the optimistic person in me thinks that by that time we will have hopefully a better situation with the pandemic, and then hopefully if enough people are vaccinated and we are protected and we have safety around the situation, everybody will be back to school. So it should be looked at as a beyond the pandemic kind of a strategy for this bill, rather than looking at what do we do when everybody is on Zoom meetings and the school is virtual. And that's what I was suggesting. And then we need a long-term strategy going forward. What are your thoughts on that?
Yeah, I agree that we do need a long-term strategy, and I see the value of this being incorporated for long-term, because I don't see it as remedial. I see it as raising the bar for what we look at. And an example of that is because students can be counted as present for the day, that could mean that they are in school detention for 50% of the day, but if they attend the other 50% of their classes, they're counted at present. And even though they missed half of their learning, and that would be even if they were in class for the full day. So there are certainly examples where previous to the pandemic, that this would force schools to care more and for teachers to pay more attention. And I am a former teacher here in Connecticut. to really value that like attendance isn't enough, that engagement is the priority. And if that's where we set the bar, then we're directing services. I'm wondering, are you meaning that this doesn't have a place in this bill because it is a long-term solution?
No. There is, but we need to probably look at the strategy and then put the effort into beyond the virtual schooling, because I think the definition of engagement would be different in virtual versus real world.
Right. Would it be helpful if I share the definition we've come up with?
Is it in your email?
It is.
Okay, you can share it in few words. Yeah.
Great. Engaged students participate in 75% or more of learning opportunities, whether in-person, hybrid, or remote, by signing into lessons, completing assignments, and participating in learning tasks. Engagement is measured by student participation and output.
Okay. And one more last question. Is this going to be more burden on our overstretched teachers to get this data? Is this going to cause more stress for them?
So we have a number of ways that we're thinking about. Like right now, attendance is given daily, but we have other things written in the brief where it's not just a teacher's recording one more metric. It could be that in reporting terms, I had to leave a comment in the midterm and the end of the term report that just gave a general comment on students. We could do something where it's qualitative metric that like has to include some comment on the student's engagement. I see this more as feedback with families. That's a lot more specific about how their kid is engaged in the learning, because I know when I gave families a call to say, oh, your child wasn't in class today, and they're like, oh, I thought they were, because I taught high school. So that led to change in behavior and change in action, and it brought in families as assets and part of the education. So I see this as another modality of connecting families with what's happening in the classroom and having that clarity. We also have an example of giving like a 1, 2, 3, 4 score where it's based on the percent that a child is engaged in the lessons, and that could be also done at a lesser frequency than daily.
Okay. Thank you so much for your testimony. Thank you, Madam Chair.
Thank you very much, Senator. Are there any questions from members of the committee? Seeing none, I'm going to ask you a few questions myself, madam, if you don't mind.
Please.
We were talking, or you were talking with the senator about attendance versus engagement. And I agree with that. And I think that your definition was really great. I'm wondering if that is in direct response to the idea of this committee that that students be allowed to attend remote in these emergency circumstances, even if they're considered an in-person learner, that when they stay home, that when they log in to be remote, that they receive credit for that attendance. Is that in direct response to that?
I think I understand what you're saying. Is it because of kids with cameras off but logged in and being counted?
No, so I have to be honest that that this bill, we have taken some parts of other bills and put them in this bill. And I just tried to look through it really quickly, but also listen to you at the same time. So I don't remember if we included it, but this committee has a bill in front of them that would allow students who are normally in-person learners, should they need to stay home sick, but are not so sick that they can't partake in class, that they be allowed to log in for remote and be counted as their attendance towards their graduation requirement, right? Because we have kids who are, overachiever, great kids who are saying, I don't feel well, but I really need to go to school today. So that I can get that attendance credit. We don't want that to happen. So this bill kind of allows that. But one of my concerns was, so I love your definition for being engaged versus just showing up. But the bill that we're talking about, which may or may not be in this version of SB2, it requires that the towns, the municipalities, the local boards of ed come up with what their definition of attendance would be. For instance, my children in Cheshire, they need to be on camera. They need to engage in the classroom process, and it has to be every single class down the line, not just morning homeroom. So, and that would be the local policy. So would you agree with that aspect of whether it's this bill or another bill? Or do you think it's necessary to include that language as that you came up with, that definition on the state level to make it easier for districts?
Interesting. I don't feel fully prepared to speak to that end. We haven't discussed that as a coalition, but I am willing to bring that to our next meeting and have further conversation to really dissect what are the unintentional consequences that come from that change, and what are equity, is that a form of an equity measure, and does it, what are the consequences if implemented in that way? So I can bring that back to our coalition.
Yeah, I would greatly appreciate that, because I have heard from parents across many districts that this is a huge problem, that their kids aren't getting credit even if they're doing the work in remote classrooms because they had signed up to be an in-person learner, and so even the classwork that they're doing, they're not really getting credit for because they're considered absent. And so we wanted to make sure that kids are, we are enticing kids to show up and be there and do things. And so I think we have to walk that line, right? So I would really appreciate your input.
Yes.
That would be fantastic. Thank you.
I will.
Are there any other? Oh, go ahead, ma'am.
I will follow through on that. Thank you for presenting that topic.
Great. Thank you so very much. Are there any other questions for members of the committee? Seeing none, you're all set. Thank you so much for being here today.
Thank you.
Next up, we have Sarah McGinnis, followed by Marilyn Mays and Ashley Brooksbank. Ms. McGinnis, are you with us?
Yes, thank you.
There you are. Hi. Welcome to the Committee on Children.
Thank you. Good afternoon, and thank you to Chairs Linehan and Anwar and to all of the members of the Committee on Children for the opportunity to testify at this hearing. My name is Sarah McInnes, and I'm a resident of Fairfield, Connecticut, as well as New Haven, Connecticut, where I attend college. And today I'm testifying as a member of the Yale College Democrats in support of SB 2. In particular, as a graduate myself of Connecticut public schools and sister to 3 current public school students, I believe that the mental health provisions of this bill are absolutely crucial and wanted to voice my support for these. Mental health has long been an under-addressed issue, and the CDC data shows that rates of anxiety and depression in adolescents have been increasing in the past several decades. Based on the experiences of my friends and my relatives, while many mental health services do exist in the state now, students need better access to mental health care, especially those students in schools that lack funding. And this is an issue of equity as well, because lower funded districts also tend to be those with majority Black or Brown students. By establishing required mental health screening training and youth suicide prevention training for certain medical professionals, school employees, and other members of the community, this bill enables those individuals who come in contact with adolescents and often have strong relationships with them to notice when a child or teen may need mental health care. It also provides these people with the tools to intervene and guide a student if the student opens up to them. This is even more important in the midst of the pandemic. As we know, in-person services are limited and social isolation has greatly been increased. And evidence from pediatric studies suggests that because of these changes, the teen suicide rate in the US has increased over the last year. Furthermore, training and education for teachers and other employees will allow them to bolster the support students get from mental health professionals already. Even in settings where people do have access to mental health care, it's important that they have other supports too. I know that in my own high school experience, I did my best work and felt good physically and mentally when I was supported by my teachers and coaches as a person, not just a student or athlete. The training, coupled with the inclusion of social emotional learning and professional development standards, would make this support possible for more children and easier for teachers to provide. Lastly, I wanted to add my support for the provision of the bill that allows students in kindergarten through 12th grade to take up to 4 mental health days off. Especially in high school, I remember having a high workload and becoming very stressed about pressures to succeed and complete my work while also doing my best in sports and extracurriculars. Pressures placed on students do add up and it becomes very overwhelming at times. I know I would have greatly benefited from being able to take a mental health day off, but it's not something that's currently really provided for or given an opportunity for students to do. And this provision would change that. And it would also help to legitimize kids' concern about their mental well-being, reduce stigma around mental health, and show them that it's okay to take a break and it's necessary to take care of yourself. After conversations with my own siblings, other students in public schools, teachers, and administrators, I've realized that the effects of the pandemic will be felt for years to come, especially the effects on the well-being of children and adolescents. Passing this bill would be a crucial step in addressing and improving the social, emotional, and educational outcomes of students in the state, and that is very important to me. And as such, I urge the committee to support SB2. Thank you so much for your time.
Thank you so very much, Ms. McInnes. So you couldn't see me because speaker view shows, but I was like pumping my fist when you were saying some of the things you were saying. First of all, I want to thank you for being a young person coming to this committee and talking about the way things would have impacted you had they been in effect when you were K through 12. So I appreciate that greatly. I think we need more voices like yours. So I really can't thank you enough. Let's talk the mental health days. You said something so important that like got me fired up, right? We have been discussing the idea of mental health days for a while. You know, we want to make sure that it's an excused absence. But you brought up the point that I've been screaming for the longest time. It legitimizes a child's right to take care of their mental health. And I think for me, I think that's the most important part of that provision. I didn't send my kids to school Friday. They had a mental health day. You know, they needed it, right? But I wasn't so worried about getting the time off from school for them. I was more worried that my children needed to realize that this break was important for them to refresh, right? So can you talk a little bit about why you feel that legitimizing the idea of a mental health day, how do you think that that would affect especially adolescents?
Yes, of course. I think that right now, obviously kids are allowed to stay home if they're sick and whatnot. But because like that definition doesn't include mental health or like one's mental well-being, I know like myself and other students, like especially in high school when there are like a lot more academic pressures, there's like a feeling that you can't take that time off because you're not justified in taking it off. Of course, like an excused absence requires your parents to call in and explain why you're not at school. And I know students who have been like in a position where they needed to take a mental health day, but didn't feel comfortable having that be the excuse to the school and felt like their parents needed to explain that they were sick or be more vague about it. And I think that it's really no different than a kid staying home if they are sick. It's just a different type of health that they're taking care of. And that by explaining this, especially from a young age, like starting in kindergarten, as this bill says, it does really legitimize that and makes it clear that like this is a legitimate reason and that you need to take care of yourself and not push yourself to a breaking point in academics.
You are absolutely right. You are completely fantastic. And I am so happy you came here today to share your perspective. Thank you so much. Are there any questions from members of the committee? No, look, you did such a great job that there are no follow-up questions. So thank you so much, Ms. McInnes. We appreciate you a lot.
Thank you, Representative Linehan and the whole committee.
Thank you. Have a great afternoon. Next, we'd like to call, please, Marilyn Mays, followed by Ashley Brooksbank and Cindy Jackson.
Good afternoon.
Hi, Ms. Mays.
Good afternoon. Good afternoon, Senator Anwar, Representative Linehan, and members of the Committee on Children. My name is Marilyn Mathis. I am testifying today as the mom of a public elementary school student, and I've also worked directly with teachers as a staff member of the Connecticut Education Association for the past 14 years. I would like to express our concerns regarding Senate Bill 2, particularly around virtual learning. SB 2 permits school districts to provide virtual learning on an ongoing basis with the approval of the Commissioner of the State Department of Education. CEA believes this proposal would result in great harm and inequities for school children across the state. While I recognize that during times of a public health emergency, there may need to be adjustments for safety reasons, There is no true substitute for in-person education, and the implications of this bill appear to go far beyond a declared public health emergency. Due to fear and concerns about COVID, my husband and I opted to have our own daughter participate in full remote education this school year. We live in a well-resourced school district that sent devices home with students before schools closed back in March. But despite Herculean efforts by our daughter's phenomenal teacher and staff, we have seen firsthand that even in a well-resourced school district with excellent educators and staff, remote instruction is not the same as in-person education. And despite our concerns about COVID, we intend to send our daughter back to school in person in the fall. We've witnessed a number of problems and distractions that have impacted instruction for our daughter, her peers, and her teacher. Our daughter's teacher had to reach out to parents on multiple occasions due to students causing disruptions or distractions by logging in late in the morning or arriving back late from breaks, shutting off their cameras, not participating, or engaging in other types of disruptive behavior. There were also a number of technological issues that interrupted instruction. My daughter was very upset one day when in the middle of an assessment, she lost connection and couldn't get back into the assessment. I tried to help her, and her daughter patiently tried to help us troubleshoot while he simultaneously reassured my daughter that it would be okay and fielded questions and addressed concerns from several other students at the same time. Ultimately, we couldn't fix the problem and had to submit an IT ticket, and this is only one of several technological issues that my own daughter experienced, and many other students had similar problems, all of which took time away from instruction. I've also seen the toll this year has taken on my daughter's and other students' emotional and mental health, and the stress from remote learning challenges has added to this serious problem. If we are experiencing these difficulties in a well-resourced school district, I can only imagine the additional challenges and inequities in districts that don't have access to the resources we have. In fact, I've heard a number of concerns raised by teachers across the state about remote instruction, in particular in classrooms where they have to teach both in-person students and students participating remotely simultaneously. Due to time constraints, I won't go into all of those, but I've included a bulleted list of some, but not exhaustive examples to give you a flavor in my written testimony. But in short, absent a true public health emergency, public schools should advance and promote the best and most equitable instructional model, which is in-person instruction. There just is no substitute for in-person instruction. I urge you to consult the experts on this matter, public school educators who can talk about the issues with remote instruction and what is best for educating our students. And just one other point, SB2 also adds the potential for virtual parent-teacher conferences. Providing for opportunities for parents to attend teacher conferences virtually does make sense. However, it's not necessary for the state to mandate additional conferences, which are determined locally with input from teachers. Thank you for your consideration today.
Thank you very much. When we're talking about this remote learning, the ability to do remote learning, and I apologize that the sun is directly in my face. I can't get away from it. I keep moving. So I want to be very clear here. I don't believe the intent is to make it an ongoing forever thing. I will be corrected if I'm wrong, but I'm not under that impression. So let me ask you this. My kids got 2 snow days this year. And then after those 2 snow days, remote learning was implemented. That worked out really well for us, for the district. So is CEA against allowing remote learning for snow days?
I don't know if we have an official position on that. I can tell you as a mom who also had, I think, 2 snow days, our district initially was planning to do only remote learning, but there was such outcry from parents, including myself, about the need for that mental break for students that they changed and they rotated back and forth between snow days and in-person days. So I don't know if we have an official position on the snow days. I'd be happy to follow up and get back to you on that. But as a mom, I recognize the need personally for that mental health break for kids. And, my own daughter was not at all happy, and several of her peers in her class, when they found out that it might all be remote learning, right? And there may be no snow days. So, I'll be honest, I think the bigger challenge for most teachers, there are huge challenges with remote in general. If you're talking about a one-off day, there's still challenges because the way that you teach with the kids in the class in front of you and the modality you would use for remote instruction are different methods of teaching. And so it does take extra work to try to rearrange your lesson plans to work in a remote setting versus an in-person setting. So there are some concerns, and I think I would want to double check with our own experts, which are our members who are the teachers, to get their feedback. But I don't know that there is 100% opposition to like an occasional remote snow day. The one bigger problem we're hearing is the dual, having to teach kids that are in front of you and remote at the same time is causing huge issues. And we have teachers at their breaking point and students at the breaking point in some of the classrooms that have the simultaneous in-person and remote happening at the same time.
Right, I understand that. And I'm going to definitely look at the language closer. Of course, this is a Senate bill, and I'm a House member, and so the crafting of this bill was done with me in some cases, but in others, it's really a Senate priority. But I'm going to have to ask them to clarify the intent. Is it that they want remote learning dual all the time, or just that we don't have to have a public health emergency declared in order for a district to go to remote learning? And so one of the, I really always think of the snow days. I think moderation is key. I don't think we should get rid of all snow days. I believe in mental health days. I just spent a good 20 minutes talking about how important that is, right? And here in my district, we do 2 actual snow days, and then we go to just do remote learning after that. Let's be very clear. If we had 10 snow days, we'd be getting out of school 10 days later, and that is taking time away from long break of summer. And so, I think that there are issues on both sides, and I think we have learned that there is a place for remote learning. I get that it's more difficult. I get that things sometimes need to be changed, but I think in the same way that we've asked businesses to grow and adapt, I would really love it if alongside teachers and administrators on the state level, we can figure out how to make it the best way for teachers and classrooms and students to adapt to a new reality.
Yeah, and I'll be honest, I think to the extent that all and any of you can have real in-depth conversations directly with teachers and their experiences this year, that would be great. I know that some of you have had meetings virtually with some teachers already, but the stories that they're sharing, the inequities, some of what you probably heard about from other groups in well-resourced districts versus not well-resourced districts, there are so many issues that would have to be overcome in order to make anything like that work. And again, it really is a different teaching and learning method when you're remote versus in person. So, but again, the bigger concern is the way that the bill is drafted seems to be broader than simply isolated incidents such as a declared public health emergency or an occasional snow day. It seems to be much, much broader than that.
Yeah, and we will work to clarify that with the proponents of the bill. So thank you so much. Senator Anwar.
Thank you, Madam Chair. I just wanted to mention about the fact that the intention is not to have perpetual remote learning. It is, we are ready to get back in the real world whenever it's safe. So just wanted to make sure that was not the intention. And Madam Chair, you got that right from the Senate perspective.
Great, I appreciate that. Thank you.
There's some days you wanted, but that's not going to be legislated.
I feel vindicated. Just kidding. Thank you so much. I appreciate that, Senator. Are there any other questions from the committee? Seeing none, thank you so much. And I'm really glad we got to have that conversation. So I do hope you'll go back and explain that to your members. Let them know that that is not the intention of the bill. And Senator Anwar and I will make sure that we work out the language to be appropriate to the intent of the bill.
Thank you all for your time and your work on this. Appreciate it.
Thank you, you too. We have now, please, Ashley Brooksbank, followed by Cindy Jackson and Tyler Barhorst. Ms. Brooksbank? Unfortunately, I believe she's not with us, so we will move on to Cindy Jackson, please.
Thank you, and good afternoon, Senator Anwar, Representative Linehan, and respective members of the Children's Committee. My name is Cindy Jackson. I am a Birth to 3 provider and chair of the Birth to 3 Interagency Coordinating Council. I just want to start by thanking you for all your efforts on behalf of children, especially those children in Birth to 3. I'm grateful for the opportunity to share the State Interagency Coordinating Council's strong support of Section 15 of the Senate Bill 2, which aims to expand Birth to 3 services and eliminate parent fees. And speaking first about Birth to 5 expansion, we really appreciate the intent of implementing a plan to expand Birth to 3 services to age 5, but we are also aware of full implementation would have significant fiscal and program implications that were spoken about previously. However, expansion of Birth to 3 services to only children with summer birthdays between May and August may be a reasonable expansion with less fiscal impact. And it's also an opportunity to develop a collaborative system with the LEAs on a smaller scale. And that would probably address some of John Flanders' issues around how to hold meetings. The system change is supported by the report generated by Preschool Education Work Group that Commissioner Bai already spoke about. And this report supported summer birthdays from birth to 3. This would help children who are eligible for early childhood special ed. This would allow for one transition into the school program at the beginning of the school year. For children who are not eligible for early childhood special ed, this would provide some continuity of services throughout the summer, when more options for early childhood programs within and outside the district would be available in September. The goal would really be to eliminate multiple unnecessary transitions over a short period of time for both the child and the family. In spring of 2020, after the pandemic began, children were unable to transition because the schools were closed. The Office of Early Childhood and the Department of Ed supported continuing Birth to 3 services through the summer of 2020. Although the pandemic was unfortunate, we actually got to see how this would work, and it did work well. Parents described positive transition experiences. Birth to 3 programs worked collaboratively with schools to do evaluations and PPT meetings that occurred so that when school began in September, the children were ready to go. So I think it was a really good opportunity to see that providing Birth to 3 to just summer birthdays did work. As far as elimination of parent participation fees, in March of 2020, the governor, through executive order, suspended parent fees. I think the Office of Early Childhood did not want families to have to drop out of Birth to 3 at this critical time. We do support the children's developmental and behavioral and social emotional needs. Families were really grateful for that. They were able to stay in programs. And the important part about that is many of these children, once they drop out, these children historically.
Sorry, your time allotted is,
okay.
You can please summarize in 2 or 3 sentences? Thank you.
Sure, sure. So the children that drop out of Birth to 3, we know historically, many of these children end up showing up in kindergarten with more developmental issues. So really being able to keep children in Birth to 3 is really important. We know there's a fiscal impact to that. Commissioner Bai said it's about $1.2 million. We also know that commercial insurance revenue in Birth to 3 is on the uptick with some of the changes that they made, and hopefully that will help with you know, making up in lieu of the parent fees. So it is hoped that the Commission on Children will support continuing Birth to 3 services for summer birthdays and eliminating the parent fees. Thank you.
Thank you very much for your testimony. That was extremely helpful. And I just want to make sure that, are you, did you submit written testimony as well?
Yes, I did.
Great, thank you. And it includes everything that you just spoke about?
Yes, and a little bit more detail. And the State Interagency Coordinating Council is also available to meet. We actually have a ad hoc subcommittee that's looking specifically at the parent fees. We'd be more than happy to give you more information on that.
Please, we'd appreciate that greatly. You know, we'll be getting this out of committee hopefully, and the work won't stop then. So the sooner you can provide us with more information, the better, but we're going to probably want that information whenever you can get it. Okay. We don't want to limit you.
Great.
Great. Thank you so much. Representative Foster.
Hi.
Hi.
Thank you so much for being here today. I just wanted to take a moment to thank you all for the work that you've been doing throughout this pandemic and in general. The Birth to 3 program and services are indispensable to the communities who benefit from them. I know, speaking as one of them, we can't possibly imagine what we would do if we didn't have access to the amazing services, even as it transitioned to being remote and in a web conferencing system. Our Birth to 3 providers are part of our family, and we couldn't possibly imagine parenting without them. So thank you so much for everything that you all do. You are great.
You're welcome. Thank you very much.
That was wonderful, Representative Foster. I'd like to echo your sentiments.
Thank you.
Are there any other questions from members of the committee? Seeing none, then thank you very much, Ms. Jackson. We appreciate you being here, and I look forward to speaking with you.
Thanks.
Sure. Next, I'd like to call, please, Tyler Barhurst, followed by Father Romans and Jeff Leake. We'll give Mr. Barhurst a minute. I'm not sure if he's able to unmute.
Yep.
There you are. Hi.
Hello. How are you? I apologize. I was dropping my daughter off at cheer, so I'm doing this from a vehicle, and I'm a little disorganized compared to what I would usually be. But
no worries.
For those of you who do not know me, I am Tyler Barhurst. I am Tristan's father, and I want to thank all of you for taking the time to discuss this important bill today. There are very few people on this earth who could imagine how much this issue means to all of Tristan's family and friends. Tristan was truly a gift to this entire world. He was literally the smartest, kindest, and strongest and bravest kid that I ever knew. And I could go on for years talking about how great he was. But I know we have limited time, so I'll simply say, to me, he was perfect, and he always stood for what was right. And he, as I look back at the time I had with him, he was more of an example for me to follow than he was a kid that I had to steer in the right direction. Since that awful day this summer, all of the loved ones that Tristan left behind have been left to wrestle with a lot of questions about the things that would have prevented this had they been just a little bit different. You know, every day we ask ourselves, what if that ice cream truck was facing the other way? What if there had been a sign activated on the sign? What if that Jeep had been going just a few miles an hour slower? And I ask myself every day, what if I had yelled out to him even 1 second earlier? We struggle with those questions every day. And some of those questions I know we'll never find answers to. But as legislators, you guys have your own questions that you have to face because of this. And I think the most important one is what can be done to make sure this never happens again. And I think, fortunately for you, that answer is largely in front of you now in the form of this bill. I cannot think of a more important purpose for this committee than to make sure that all the precious children in the state are protected from harm. I mean, that should be the primary focus of this committee. And even though the concept of protecting kids probably seems obvious to all of you, I think it's worth taking a moment to think about what's really at stake here with this particular bill. And that is what's at stake is the tremendous opportunity that you guys have right now. And that opportunity is to make sure that no other parents have to end their day by going into a room and sitting on an empty bed, knowing that they don't get to hug their child goodnight again. And you can make sure that no more parents have to put themselves together each morning when they put one breakfast spot out on the counter instead of two. And you can make sure that no sisters are going to feel lonely when the house is quiet instead of having wrestling and laughter. And you can make sure that a teenage driver isn't going to have to carry around the pain of having struck one of these kids that are coming and going from one of these trucks. I'm thankful for all the progress that everyone involved has made in moving this from a concept to a bill. And I ask that you guys continue to act on this opportunity and move this bill forward, along with any other additional protections that you see fit. For instance, the Hartford ordinance, I think, is a important part of this. And I was also happy to hear about maybe some educational aspects, whether those are added in as part of this bill or through regulations later on, because teenage drivers should also hear about this in driver's ed. But as I said earlier, Tristan always stood for what he believed was right. And I know if he were here, he would think this was the right thing to do. And I just ask that you all honor him by pushing this forward, and that you recognize this bill again as Tristan's law to honor him. And thank you.
Thank you so very much, Mr. Barhorst. I am so sorry for your loss. I can't imagine the pain. And I think that you demonstrated it so well when you were talking about putting an empty place at the table. I want you to know that as I've been speaking to Christy and to you through her, I am committed to passing this bill, not just out of this committee, but also into law. And I will do everything that I can to ensure that that happens. I'm so glad that you like my idea of education. To give you a little bit of information, the substitute language, which I'm going to look to put through, provided that the committee members are with me on this, is very similar to some of the education that I do in preschools and elementary schools regarding water safety. We have a book made, we talk about that, and I think that I think it's important that we do that. But I didn't think of an equally great idea, which you just came up with, was that this should also be included in driver's ed courses. And when you said that, it's like a light bulb went off. I think that that needs to be done too. So I will certainly be talking about that with my co-chair and members of the committee, and also discussing that with the chairs of the transportation committee. Because as I've said previously, that this bill, we put forward the same bill that the transportation committee put forward. We're all trying to put forward something that we think is going to make for real change. But I think that your idea is brilliant. And I will discuss with the chair of transportation and see that we both put that in our substitute language that we get out of our committees. So thank you so much for that.
Thank you.
Are there any questions from other members of the committee? Senator Anwar.
Thank you, Madam Chair. I just wanted to echo your sentiment, Mr. Parhorse. Thank you for sharing your pain, and I'm so sorry you had to experience this, and I'm so sorry that all that you have endured. I can just say that this is one of those days that you want to have a meeting in person, because this is the time I would want to come and hug you and just let you know that we hold you very close to our heart and your family. And we cannot do a whole lot except we can just make sure we try our best, as you are, to save more children from being impacted this way. And that's something we can do. So I'm sending you my love and my virtual hug. Thank you.
Thank you. And I just, one thing that occurred to me with this, I just want to comment on, some of the training and educational things that one thing I don't want to happen is we have the warm season coming, and these trucks are going to be back on the road soon. And I would really like to see what is on the paper or with the Hartford ordinance, get that enacted, get it in force as soon as possible. And then if we have to do other language separately, then we should do that. And I like the idea, but I think this needs to get on paper and get on the floor now.
Right. Thank you for that, Mr. Barhorst. I will say that we have the ability to write the date of implementation for each section. So because education and training does typically take longer to develop, we can pass a bill with that language in it and have its implementation date be later than some of the other aspects of the bill.
Again, my concern would be, let's get this passed now, and just so kids are protected now, as opposed to, because if I don't know how I would, live with myself if something like this happened again.
I completely understand that, and I can say that I really do not believe that an education component in the bill would hold up the bill from passing in any way. It's easy to do. We do this a lot in the legislature, and I'm very confident that we will have the support for the education component. So I don't think you have to worry about adding that suddenly derailing the bill. I mean, of course, we will hear from people, and we pass things out of committee that we know we have the votes for. So are there any other questions for Mr. Barhorst? Nope, hearing none. Thank you very, very much for your time. And again, on behalf of the entire community that I represent, our most heartfelt and deepest condolences to you and your family.
Thank you.
Thank you. Father Romans, please, followed by Jeff Leake and Hamish McPhail. Father Romans, hello.
Hello, my gratitude to the co-chairs, the ranking members, and the members of the Children's Committee for this opportunity to address you. My name is Father Jeffrey Romans, pastor of St. Bridget of Sweden Parish here in Cheshire, Connecticut since 2014, and also with over 3,000 families that are members of our parish. And that also makes me the priest director of St. Bridget's School with a population of 300 plus students from over 200 families from 20 different towns. I'm speaking to you today to put my support behind and ask you to fulfill your commitment to the people of state of Connecticut by passing House Bill number 6566 to enact safety protocols concerning the use of and operation of ice cream trucks and frozen dessert vending trucks. On June 12th, our school and parish family experienced a tragic loss when Tristan's life came to a sudden end after that tragic incident between the ice cream truck and another vehicle on Weiss Road in Cheshire. What was the last day of the school year, normally a time of great joy, in an instant became a horrible experience for not only his family, but our whole parish family as well. I was not at the scene, but was contacted immediately by the Cheshire Police Chief and notified of what happened and that a number of my students were there present and witnessed the horrific event. I immediately responded to the scene to be with those that witnessed this tragic incident and rushed to the hospital in New Haven to simply be with Tristan's parents. You see, they are my personal friends as well as my parishioners, and this loss was very real for me as well. The Barhorse family lost their son and brother. The parish and school family and myself lost a member of our community, but also a dear friend to so many, a smile that truly illuminated our halls in the school each day. As we continue to work through this tremendous loss and do our best to honor Tristan's memory, while we continue on each day without his smile and presence here among us, I implore you as members of the legislature to act and pass this House Bill 6566 so no community ever has to experience the horrific event in the future. This is not a political issue. It's not a partisan issue. It's a common sense legislation that could save communities from experiencing tragic losses in the future. Children are our future, and I trust that you will do all that you can to vote to ensure their safety and to reduce the risk of another community and another family to have to endure the pain that our community and Tristan's family have had to endure since last June. Please vote to pass this bill today, and please name it Tristan's Law to honor our dear little friend, an amazing and incredible soul. Thank you.
Thank you very much, Father Romans. We really appreciate you being here, and your love for your students and your parishioners truly shows. So thank you very much. Are there any questions? Representative Wiehlander.
Thank you, Madam Chair. Father, I just wanted to say thank you for sharing your perspective this afternoon and reminding us that a loss like this affects entire communities, and its impact is very far-reaching and has very broad. So I'm having my district also faced a tragedy this past weekend in the loss of a child, and it is a tragic experience that has a stronger impact than I think most people realize until they're in the middle of it. So thank you for reminding us all about that part.
Thank you for understanding that.
Thank you, Representative. Yes, I can say that as a representative for the town of Cheshire, this is a community-wide tragedy. If this happens to a child in anyone's district, we all feel the pain. And so I'm very sorry for the loss in your district too, Representative. Are there any further questions for Father Romans? Hearing none, thank you, Father. We appreciate your time.
Thank you for the opportunity.
Next we have, please, Jeff Lee, followed by Attorney Feinstein, and then Jocelyn Preston, please.
Good afternoon, Senator Anwar, Representative Linehan. Actually, I really was looking forward to this because it's been quite a while since you and I were in a similar setting, and just wanted to say congrats on all that you've done since then. I appreciate it. And I'm going to be really short here in terms of you've heard pretty well from Tom and from Marilyn our concerns. And I think around 5 o'clock, there was a conversation, I'm listening to another committee over here on my other computer regarding the intent of the distance learning, remote learning. It was not in any way intended to say, yeah, let's just be able to make this happen. It obviously caught our eye because it's limited to high school students, and that is the one where some people feel, I think, that's where distance learning might be the most successful. But again, you heard from both Tom and Marilyn about our concerns, and the gigantic concern of ours going forward is that whenever we do distance learning for students, what we have to make sure of, and Marilyn emphasized this a lot, is that the instructional model of having kids right in front of you and kids on a computer screen is like horrendous. Our teachers have done it this year. They've done their best this year, but clearly, it is a model that we cannot consider moving forward. So I appreciate any conversation that kind of makes sure that the idea of distance learning for students is not something that we think can just go anywhere. Clearly, some of the other provisions of this bill we support. I mean, we support some of the things that are here, but are very concerned about that one, and we want to make sure that we make progress on this whole idea of adverse childhood experiences. Our national organization has done much work on this. We know how important it is. We know states like Ohio have done tremendous work in this area of using a tool to identify what's going on with children as they come in and addressing their trauma as soon as we can get to it. So we appreciate all that this committee is doing to make sure that we address the issue of kids that are traumatized and dealing with social emotional learning in a much larger scale. So with that, I'm going to stop. And again, I think my two colleagues did a terrific job, so I don't have to spend any more time than I have. But again, great to see you, Representative Linehan.
It's been quite a while, hasn't it?
Yes, it has.
Who would have thought?
Now your committee's going to say, what are they talking about?
Would you like to tell them where you used to teach, Mr. Leek?
Yes, please, Jeff, okay? I taught, I taught in Cheshire, and at some point had Representative Linehan as a student. And in any case, I hear Ray tells me that you particularly noticed some way that you got in trouble with me, which I do not remember. So,
well, I do.
What's that?
I do.
Oh.
I was a troublemaker. Look, it's fine to say it. There's a reason why I don't use my maiden name, because I was such a troublemaker when I was in high school.
Yeah.
Listen, it's really great to see you. You have such great experience in the classroom. So I think it's really important that you're here today to talk about this. So I don't know if you missed the conversation, but I think that the intent of the bill, we need to clarify it, because we're not wanting distance learning to be available all the time.
Right.
And I will say this, and I've said this 100 times and I'll keep saying it. As a parent, I hate distance learning. I really do. But I recognize that in some instances, it has its place. So we were talking earlier, the language we're hoping to clarify would be that it would be distance learning per the Commissioner of Board of Ed. We said that because we didn't want it to just be in an instance of a public health emergency, right. Which is how it is now. So one of the things that I brought up is something Cheshire's doing. 2 snow days, actual put on your snow gear, go out and sled in the snow, no school snow days. And then after those 2 snow days, they're going to distance learning so that kids can be sure to have a summer. Because if you remember a few years ago, I mean, there were like 10 snow days and kids were getting out almost in July. And so I think that there's a place for distance learning. If we were to clarify that and make it known that we weren't looking for distance learning to be a co-track every day of the school year, would that help get you guys on board?
Most likely, yes. And there was a discussion in one of our locals, as a matter of fact, way before the pandemic, about thinking about distance learning it was only at the high school at the time, to replace snow days. I think we've done okay this year. Some superintendents have called snow days, meaning, no, you don't have to come to school in any way, shape, or form. Go out and have fun. And others are looking at the calendar and being concerned. So yeah, as long as, again, as long as no one in the world thinks that distance learning is the way to go for any age kid right now, we could probably figure that out. So.
Okay, great. Then that'll give us another reason to chit chat
Yep.
again. So I could
Absolutely.
remind you of how terrible a kid I was. Thank you so much for your testimony and your input. Senator Anwar has some questions for you.
Thank you, Madam Chair. Mr. Leek, thank you so much for your testimony. Now that I've heard that you were one of the teachers for the chairwoman, I wanted to ask you a few questions.
Uh-oh. I don't remember any of the bad stuff. I'm telling you right now. So
I don't expect, because there wasn't any bad stuff, right?
But
so
that could be.
Well, we'll have to talk offline about the other stuff.
Right.
But was she always into saving the world?
What's that?
Was Representative Lanahan always saving the world?
I'm not sure about always saving the world, but clearly an activist in any number of ways. So.
Well, you guys did very well. She is saving the world right now.
Absolutely, absolutely. Yep.
Thank you so much for your testimony.
Thank you.
Thank you, Madam Chair.
Thank you, Senator. And I will point out that while I was attending class at Cheshire High School, I wore ripped jeans where I wrote on my knee, on one knee it was abolish and on the other it was apartheid. So I
Okay.
was that activist.
Yep. There you go. Right.
My goodness, time flies. So thank you so very much, Mr. Leek, for your testimony and your input. Please, let's have a conversation again. Give us a few days so that we can and we'll get it out to you and your organization so that you can kind of give us a thumbs up or thumbs down. Okay.
Thank you. Thank you for that. Thank you for all you're doing
Have a
as well.
great day.
Absolutely. Yep. You too.
Thank you. That's great. He was great. We have Andrew Feinstein, followed by Jocelyn Preston and Daniel Pearson. Hello, sir. How are you?
I'm good. Well, thank you for having me before the committee, Dr. Anwar, Madam Troublemaker, and members of the committee. I am so pleased to hear that. I am a little feeling strange about this testimony because I'm speaking on behalf of SEEK, and we have lots and lots of issues with SB2, which I want to work out with you because I know how important this is to you. Let me just go through them in bullet order before I get interrupted. The QPR training in sections 1 through 9 needs to be expanded in two ways. One, it needs to include social emotional learning, including restorative justice as part of that training program. And two, it needs to be mandatory for all SROs, which is not covered by the bill now. Two, next issue. The language in section 14 instructing teachers to inquire into any hardships the student's family may be experiencing, we're afraid it's going to lead to intrusive and alienating conversations. It's not the job of teachers to become social work investigators. There are others who have that jobs, and to the extent that teachers become aware of this, they are mandated reporters. Section 16, we were just talking about, the language would allow the closing of high schools and going all virtual. We can see no justification for that, and so that clearly needs to be limited. Section 19, mental health days. Look, on one level, it's unnecessary. Kids take mental health days now anyways, and and they have a certain number of days that they can be absent without any repercussions. And it's going to encourage absenteeism. We're also a little concerned that for kids with behavioral issues, instead of when they're sent home, it being counted as a suspension, it's going to be counted as a mental health day. And that really is going to, already there's an underreporting of kids being sent home. Sections 20 and 21 has the collecting of data on adverse childhood experiences. We are really troubled by that. We know what communities have widespread trauma, And to the extent we know that a child has suffered from a traumatic experience, we need to deal with that child as an individual, not as a number on a chart. Further, the definition of adverse childhood experience is unduly narrow. It doesn't include, for example, a relative who died of COVID. It doesn't deal, for example, with a sibling who was shot up in a gang warfare, unless the child was actually present. So I don't think that's a very useful section. I'm not going to go into the birth to 5 proposal because John Flanders already did that and made promises that we're going to do everything we possibly can to fulfill to come up with a way to make that language compatible with the current IDEA. Our concern now is that a continuing, birth to 3 program for kids 4 and 5 who are who do not qualify for special education really.
Sir, the time allotted has passed. If you can please summarize in 2 or 3 sentences. Thank you.
Mr. DiDio, you do it with the most beautiful smile. I'm
Actually, if I may, Mr. Feinstein, as a question, I'm just going to say, please finish your testimony as you intended.
Thank you. I'm almost done. I'm not. So we're going to deliver on on trying to do something on birth to 3. The issue about birth to 3 providers not being able to make recommendations at PPT meetings now is a serious one, and that can be remedied in this bill. And then finally, the task force has a mandate. The task force in Section 45 has a mandate far broader than early childhood, yet the membership's entirely from the early childhood community. I'm not sure we need a task force, but if we do, ought to be more narrowly focused, and any task force in education ought to be made up 50-50 of providers and consumers. And by consumers, I mean parents and their advocates. So that's what I have to say. We're delighted to work with you as we always have to try to develop the best possible legislation. Thank you very much.
Thank you so much. I was taking copious notes, but I'm sure you enumerated all of those in your testimony, which we will be looking at this evening and tomorrow for sure. I just want to say, I want first a little bit of clarification. When you were talking about training for SROs, were you referring to the SEL training, or were you referring to QPR training?
Well, I think providers need both, and just within the list of providers, SROs are not included. In sections 1 through 9, you cover virtually everybody else in the school system, but you don't include SROs. So just that.
So,
for both kinds of training.
Okay, so I just want to point out the language in this bill, and I'm thinking it's in the most recent LCO filed. The language of this bill exactly regarding the QPR training is exactly the same language that was in the bill that we already passed out of committee. That actually it does allow for SRO training for QPR, because what happens is the Department of Health, then local Department of Health, sends out invitations to certain classifications of employees, and that's including police officers. And police officers fall under the SRO umbrella. So they are included in QPR. As far as the social emotional learning training for SROs, I love that. I think it's hugely important. I was made aware by Representative Wieslander that is something that's being spoken about in education. And so I'm going to need to go co-sponsor that because I think it's extremely important. However, I am going to take it under advisement and speak with my co-chair to see if that's something we want to mirror here in this legislation.
Well, there's a difference between making training available and making it mandatory. And SROs have a very particular position in schools, and there's been some great SROs, and there's been some very poorly trained SROs. And if there's one group that really needs training in how to deal with kids on the brink, it's SROs.
Yeah, I really agree with you. And I will say that I had a conversation with many people district online, and we're talking, there was somewhere around 200 comments. And in my district, people don't understand. They think that SRO officers are the greatest thing since sliced bread. And you know what? In my district, they are. We have a wonderful SRO. But then I provided data from across the country that shows that that's not always the case. And while Connecticut is fortunate in many ways, I really don't think that mandating extra training is too much of an ask, especially when we're talking about people who touch the lives of children every day. I think that's extremely important, and I appreciate you bringing that to the committee's attention.
Yeah, I have a lot more to say about SROs, but this is the wrong forum to do it in. And, but you know, I agree that in some districts are the heroes, and other districts they're not.
Agreed, and I think that the training can be utilized in both, where some may need it, it can't possibly hurt for those districts that already have great SROs. That's my point.
Yeah, and I've been on the SEL collaborative, and I've learned a lot on that about suicide prevention and QPR, and a lot of it's counterintuitive. You know, and it's really important that anybody who's dealing with a child in that sort of crisis understands what the best science is on how you deal with those kids, and relying on your instincts may not be the best thing to do.
There's pesky science again, science and data. But thank you very much for bringing up the Social Emotional Learning Collaborative, which was developed out of a bill out of this committee in 2018, and they've really done extraordinary work. Thank you so very much for that. We have a couple hands raised for you. Senator Anwar.
Thank you, Madam Chair. I think Representative Wielander was ahead of me, so I would yield. It's okay? Okay.
Of course, such a gentleman. Thank you. Representative Wielander.
I will yield to my ranking member. Thank you, though.
Okay. Thank you, Representative Wielander. I just wanted to ask you, Mr. Feinstein, you touched on something. You said, if I heard you correctly, that the QPR should not be implemented by the teachers. Did I hear you correct?
No, you did not. What I said was that that piece of the legislation, which tells teachers to, quote, inquire into any hardships the student's family may be experiencing in Section 14, is really not the role of teachers. That's all.
Okay. And then
QPR absolutely should be part of the teacher's toolbox.
Good. The second part I wanted to clarify was, you said that the birth to 3, there is no reporting requirement. Could you expand on that? And maybe we can fix it.
No, I mean, that's, I don't think that's what I mean, what I said is that there's now regulations that say birth to 3 providers cannot make recommendations at the transition PPT meetings. And that's got to be changed. They've got to be able to speak freely like everybody else at the PPT. And indeed, the birth to 3 providers are often, except for the parents, the people who know the child the best. And they certainly should be able to make educational recommendations at a PPT meeting.
And how did that change? What was the rationale for that change that happened historically? Do you know offhand?
I don't know. I've been trying. I've talked to Commissioner Bai about this last year, 2 years ago, before COVID. Who knows how long COVID's been around? And I'm not clear as to why that's in place. I do know that, you know, public school districts want to be able to make their own decisions and don't like outside people telling them what to do. But that's what a PPT is all about, allowing everybody who works with the child to make recommendations.
Thank you. This is very helpful. Thank you for your testimony. Thank you, Madam Chair.
You're very welcome. Representative Wielander now, for real.
For real. Thank you, Madam Chair. Thank you, Senator Anwar. Hi, Mr. Feinstein. I believe I heard some of your testimony the other night, maybe both education public hearings, the marathon meetings that we had. And I just wanted to touch on a couple things. One, that there was in the House Bill 6557 out of education, there was a provision in section 12 discussing having specifically school resource officers complete the same social emotional learning and restorative practices and training provided to teachers and administrators. So I think that's a great thing to make this committee aware of as well, that kind of practice. And
I agree.
And also there was also a section 1 of that same bill is talking about creating a universal mental health and resiliency screening for and I think that it's really important if we're going to start looking at how to address these situations in the future. We need to know exactly what we're looking at, and more data is always helpful with that fact. And I'm curious to hear your thoughts on the idea of labeling mental health days as something that would contribute to increased delinquency, and rather than acknowledging something that is a part of your overall health and well-being, and giving young adults permission to act on that. I was wondering where your thoughts came from that.
Yeah, I mean, in the first place, I think that kids take mental health days all the time now. And I've certainly seen it in my kids deciding to take mental health days, and they do, and there's, as long as it's in reason on number, there's no penalty and there's no requirement for a doctor's note if it's a short-term thing. I think, though, actually labeling it that way kind of opens the door to what should be a ceiling will become a floor, that it'll be sort of a feeling that you've got to take those days. I also am very concerned about the fact that right now it's a fairly frequent practice that when a child's misbehaving at school, the school will call the parent and tell them to come pick up the child. We've been fighting to make sure that those count as suspensions, because they are suspensions. If there's an availability of a mental health day, we're concerned that the school will label it in that way. And in terms of putting downward pressure on exclusionary discipline, having suspensions labeled as something else is not helpful in that process. So I mean, I think that we ought to, as a society, recognize that mental health is every bit as valid as physical health, and that where a child's feeling overloaded, stressed, and all that they ought to be able to take the day off. But stipulating a certain number of days for mental health seems to me to be kind of the wrong way to go on that.
Okay, thank you for that clarification. Do you think that if the language were amended to include stipulation that it would have to be declared ahead of time and not in conjunction with a punitive action by the school, would that alleviate some of your concerns?
Well, I do think we have to tighten up the rules about sending kids home. I think the rules are actually fairly clear. It's just that schools may not be complying with them. I think we can tighten that up some. I guess I'm more concerned about saying there's going to be 4 mental health days. I prefer to say that that mental health is as good a reason to skip school for a day as is physical health.
Okay.
I mean, I think that's the issue. That's parity between the two types. And it's also in a way unnecessary because if you skip incidental days of school and it doesn't total 10 days in a semester, then there's no consequence. And frankly, even if it's more than 10 days, there's no consequence. And at a time now when we have such an enormous problem with absenteeism during COVID and probably post-COVID, I'm not sure we ought to be passing legislation to encourage more absenteeism.
Well, I appreciate your feedback on that. Thank you for your time this afternoon.
Thank you very much, Ms. McClellan.
Thank you very much, Representative. Are there any other questions? Seeing none, you're off the hook. Thank you very much. We
Thank you.
appreciate your input.
We've asked for a meeting with you, and I hope to get together with you real soon to go over some of this stuff if we can.
Absolutely, you got it for sure.
Thank you.
All right, thanks.
Bye.
We have Daniel Pearson, followed by Jessica Welt-Vitensky. Mr. Pearson, are you available?
I am.
There you are. Hi, welcome to the Committee on Children.
Yeah, thank you. Thank you. I'll jump right in. Co-chairs, Representative Linehan, Senator Anwar, ranking members, and other distinguished members of the committee. My name is Daniel Pearson. I'm the State Director for Educators for Excellence Connecticut, a teacher-led organization with nearly 1,000 members statewide that seeks to elevate teacher voice in policy decisions. Today, I submit testimony on behalf of our members who are current classroom teachers and who work every day to ensure that their students have the best educational experience possible. These teachers work with the very students affected by these policies, and we urge you to support SB2. The consequences of COVID-19 are rippling through our communities, further exacerbating the inequities in our education system and putting incredible pressure on educators and students to navigate the uncertainty of remote and hybrid learning with very few resources. This pandemic has shined a light on the massive opportunity gaps that exist for our most vulnerable students. We must develop comprehensive strategies to mitigate learning loss from this pandemic, while also developing long-term solutions to finally address the structural inequities in our education system. Our teachers have been working with other education advocate organizations to better understand and identify what student engagement looks like in practice. We recommend strengthening this bill by adding the recommendations provided to you by the Coalition for Equity and Learning and CONCAN on clearly defining student engagement and disengagement. By having a clear definition, we can better assess the impact of our programs and have data that more accurately illustrates our students' levels of engagement. Additionally, it goes without saying that this past year has been incredibly difficult for us all, especially our youth. And now more than ever, we need to make substantial investments in our students' social and emotional well-being. SB2 is a step in the right direction towards deepening the social and emotional supports available within schools. It's long overdue for us to prioritize the social and emotional well-being of our students, teachers, and mental health professionals, and we urge this committee to vote in support of this bill. Thank you.
Thank you very much for your testimony and for your support. It's greatly appreciated. Are there any questions from members of the committee? Oh, well, seeing none, that's all. Thank you so much. We appreciate your time and your energy here today.
Thank you.
For our final person of the day, please welcome everyone, Jessica Welt-Vitensky from the Community Health Center Incorporated. Hello, madam, how are you?
Well, thank you. Senator Anwar, Representative Linehan, Senator Martin, Representative Dauphinus, and members of the Committee on Children. My name is Dr. Jessica Welt-Vitensky. I am a psychologist and the CEO and clinical director of the Child Guidance Center of Southern Connecticut, which is an affiliate of Community Health Center Incorporated. Thank you for this opportunity to provide testimony on Senate Bill 2. Left untreated, mental health issues can have a far-reaching and often dangerous impact on the child, family, and community. In this past year, CGC and CHC have provided over 125,000 behavioral health visits to 7,500 children across the state, mostly via telehealth, video, and telephone, which has proven to be effective in treating most pediatric mental health issues. But while telehealth has been great, we look forward to resuming mobile crisis and in-home therapies, especially with high-risk youth. Senate Bill 2 is comprehensive and includes several proposed initiatives that would greatly improve health outcomes for children in our state. While we broadly support the bill, my testimony today will focus on two specific components: youth suicide prevention and the Internet Access Grant. This past year of living through a global pandemic has created a nightmare scenario for vulnerable children and families. A mental health crisis is emerging at a time when accessing therapeutic services has never been more challenging, especially in marginalized communities across the state. There is evidence of an increase in demand and an increase in severity of mental illness in youth, particularly now when families are struggling to balance the risks of exposure to COVID with the risk of mental health consequences due to prolonged social isolation. Higher rates of emergency room visits due to mental health concerns for children. 6.7% of Connecticut high school age teens report having attempted suicide, and our providers consistently report suicidal ideation is on the rise in the young clients. Given this mounting evidence that Connecticut's children and teens are facing an unprecedented mental health crisis, youth suicide prevention strategies must be prioritized. Providers like me and my colleagues rely heavily on those in the community with regular access to children who are often on the front lines when it comes to first identifying a child who is struggling and helping connect that child to appropriate mental health care. We have a commitment to helping those without formal mental health training to be better able to recognize the warning signs for suicide, be prepared to ask difficult, direct questions about suicidal thinking and plans, and then know how to immediately connect at-risk children to mental health services. So establishing a statewide youth suicide prevention program and training community members in QPR really ensures that all children in the state are surrounded by a suicide safety net in their community. But identification of need is only part of the issue, particularly now when so many children are at home relying on virtual platforms to access school and healthcare. We must ensure that no child who needs care is denied access. The Internet Access Grant Program, I believe, is a critical component of Senate Bill 2, because for vulnerable families without the means to afford reliable internet access, this program would not only provide access to education, but also these families and children would be able to access necessary telehealth services to address acute behavioral health needs. Thank you for the opportunity to provide comments today, and I'm happy to answer any questions that you may have.
Thank you so very much for your testimony, and thank you for your support of the QPR training. This is something that I've been trying to get passed now for 2 years. We passed it unanimously out of committee last year, and we were sidelined by COVID. And I think it was a blessing in disguise, because now in this bill and another bill that we passed out of this committee just recently, we have been able to expand it. And COVID has shown that it's absolutely necessary. But I do have a question, if you wouldn't mind. And so we talk about the need for suicide interventions for screening. But I've heard some people say suicide rates aren't going up. And to them I say, well, it's not a giant spike, but what we are seeing is a giant spike for kids at risk, right? So we had Connecticut Children's here talking about how they had, I think it was almost a 10-point jump in kids who screened positive for risk of suicide. And then we hear about the absolute huge spike in kids who are reporting extreme anxiety. Mm-hmm. Can you briefly explain, are there like steps to how suicidal ideation comes to be, and is anxiety one of those precursors to that?
Sure, happy to, Representative Linehan. I'm happy to share a little bit more about that. Suicidal ideation is a common symptom in young people, and it's though maybe the rate of completed suicide may not be as high, the fact that suicide is the second leading cause of death for children between the ages of 10 and 24 in our state is certainly cause for major concern. And known mental illness is a risk factor for suicide, particularly depression and anxiety. What tends to happen is it's rare for suicidal thinking to be the first line of defense, but often if people are experiencing a certain amount of psychological or emotional pain and they feel like there's no other way out, then oftentimes thinking about ending one's life is a way to imagine how to put an end to pain. When it comes to children and adolescents, you have the added risk factor of impulsivity that tends to increase the risk for children and adolescents having that experience, because sometimes in a moment when you don't have the resources to think your way through, or the support around you to get past a moment when you are in huge despair, then children and adolescents tend to impulsively act on that desire, and particularly if they use lethal means, that is deadly.
Right. Thank you so much. I appreciate your expertise, because, you know, having to defend people, having to defend the numbers, because people don't recognize the incremental steps that go into this, and that QPR is really set to weed those out, those incremental steps, right? And so I appreciate you greatly for coming and saying this. And just one last question from me before I send it to my co-chair. Wouldn't it be really great if we had a ton of school-based health centers with a mental health component in it?
Oh, indeed. I mean, community health center has over 200 health center, school-based health centers across the state, and a large percentage of the numbers that I gave you about what we're doing in behavioral health are coming from school-based, and having providers in the community where children are is certainly a huge issue, and a mission for CHC and hopefully others in the community is also in recruiting members of and providers, clinicians who look like the clients they're serving, because we want to ensure that people are feeling represented, by their providers, and that oftentimes families and children feel more comfortable speaking to a provider who looks like themselves rather than somebody who they don't feel can relate to their experience. And so school-based providers in the community who are familiar and really feet on the ground make such a difference. So it would be wonderful if we had school-based providers in every school across the state. And if I may, what you talk about with QPR, I think there is a fallacy that people don't understand, that just asking questions about suicide does not increase the risk of suicidal behavior in children. And so there is oftentimes fear about asking a child directly, are you thinking about killing yourself? Have you had have you ever tried to kill yourself? We don't want to ask because we're afraid we're going to be planting a seed in a child's mind. And the reality is, and the research shows, that that is absolutely not true. And a lot of people who don't understand that feel fearful of training people to ask those direct questions. But we know that oftentimes kids need help, and there are signs and things and warning sort of flags that let us know that a child is struggling, and we need to be able to go up to a child and say, something is not right, or you're not acting the same way. Are you okay? Have you had any thoughts of hurting yourself? Have you had any thoughts of killing yourself? And only when we ask the question do we get the answer, and then we can help them.
You're exactly right. Thank you so much. And I thought I only had one last question, but you've inspired one more, and I apologize. You know, this bill, something that no one's really talked about today, but Senate Bill 2 also allows for adolescents to have a certain number of provider visits for mental health without notification to parents. I think this is hugely important. However, I've gotten some pushback, and I think that some of the pushback is from people who might not understand why it's important for adolescents to have the ability to talk to someone without having to go to their parents. So can you, one thing, explain why that's important? And number two, explain to us if that would be a benefit of a school-based mental health clinic.
So I did hear that mentioned early on in Commissioner Durant's questioning, and I believe that element of the bill is important for school-based, but not just school-based, also outpatient-based care and other resources, because we don't know where a child will present for services. And sometimes, particularly adolescents, want separation from school because of concerns that what's going on in school, it will get back to teachers and a reputation, et cetera. So that element of the bill is extremely important. Adolescents who feel at risk of judgment or potentially expulsion from home or potential abuse need to be able to reach out to get help from providers and not have to ask permission. And so the intention, I believe, of that section of the bill is to provide for safe harbor for youth of a certain age to be able to say, I need help. We have encountered, in my experience, I've been working in the state of Connecticut as a licensed provider since 2012 and have been a licensed psychologist in the state of New York since 2006. In my experience, adolescents who do take advantage of legislation around permission to seek treatment without parental consent typically are doing so for reasons related to concerns about safety, whether that's safety because the reason they need help is because there's some sort of trauma going on at home that they've been told or they've been implied that they cannot talk to other people, so they come to treatment because something's going on, or they've been told that they cannot access therapy and they know that they need it and they're struggling, or for even a very significantly impacted population are LGBTQ plus youth who are not out to their families and risk of outing themselves would risk potentially being ejected from the home. And so many of those youth are at high risk for suicidality and other high risk behaviors and homelessness, that I would much rather give them the option to get the help they need and with a trusted licensed adult in a provider who can help guide them and figure out how to get them to a safe situation, even if that means involving caregivers down the road. And that is a commitment that we providers do make when a child or an adolescent comes to us seeking treatment without parental consent. We do commit to continually assessing for whether or not parental consent can be obtained and whether or not the reasons they're coming are justify not seeking that consent.
And so if you determine on your own that it's justified, do you need the child's consent to alert the parent?
So again, as long as safety is an issue, you would need to speak to the child about that. However, there was a piece in Senate Bill 2 that raised a little bit of a concern for me as a provider, the idea that the language is that if there's a concern for the child's well-being, that there's a safety, a limit of confidentiality with the child would force telling the caregiver. I wonder if that's risky in that if there's a safety issue, for example, a suicidal child, but the caregiver would present a different safety issue, for example, if in a physical abuse situation, when we think about limits of confidentiality in the practice of mental health provision of services, a limit is if a child is a danger to themselves or others, you need to tell somebody, but I don't know that we should be forced to tell the caregiver if the caregiver is a dangerous person.
Got it. Okay. So that provision was actually something that I was strong on, and I thought that was important, but you are right. You have clarified that the law is that they have to tell someone, not that it has to be the parent. So yes. I appreciate that. And I think that change is important. I apologize that I got that wrong. So thank you for clearing that up for me. But hopefully we will also have so much QPR training out there that parents will take the training themselves and will be involved in their children's care. So thank you very much for that. And so now we have some questions from Senator Anwar.
Thank you, Madam Chair. Thank you. I think it's Dr. Welch-Vitensky. Dr. Vitensky, thank you for sharing your expertise and your experience. I wanted to ask you again on the adolescents about the number of treatments. Is 12 better than 6?
Yes. I think that for particularly, I imagine that an adolescent seeking treatment without parental consent is ready to be in treatment. But that said, it can be difficult to form a relationship and build rapport with a stranger, and particularly if there are issues of safety and worries and fears about parents finding out and about payment and things of that nature. I know We have dealt with youth seeking treatment without parental consent at our organization over the years. And one of the big concerns that adolescents have is, how am I going to afford to pay for treatment? No bill can go. I am on Medicaid, but if my parents get a bill, these are the things that come up. And so I think sometimes it does take time to build that rapport that allows for the work that the adolescent is seeking to really build, and 6 sessions is pretty quick. It's a very brief treatment. 12 would be wonderful.
Okay, because I think there's a hope that you should be able to increase and expand that, and the insurance industry obviously does not want to expand anything that the minimum that they can get away with is the mindset. The other part is that the QPR is an early identification strategy, and it has great value. There's plenty of data to support it. What would be the primary prevention strategies? In other words, can we do an intervention? I asked this question earlier, but with your expertise, can you help us? And I'll add another question to it, is that we have some federal funding that will come to the schools. If you were talking to the schools to set up priorities in a pandemic where a significant proportion of our children are going through struggles, what would be the best way to use this one-time resource to prevent the challenges the children are having?
It's an excellent question, and I'm grateful to be asked. So one thing that QPR doesn't do, and at least as I understand it, is it doesn't have a super strong training component for youth. And so one thing we know is that teens talk to other teens. Kids talk to other kids, sometimes more than they talk to adults. Particularly, this is true of adolescents. And adolescents represent the population most at risk, at least children over the age of 10. And so one thought would be to invest further resources in the type of training, QPR-like training, mental health first aid for adolescents, so that in the schools there are task force or committees. I know I'm from the Stamford area, and in Stamford and Norwalk, we have the Mayor's Youth Leadership Council groups where mental health was a mission. They were all trained in mental health first aid, and they partnered with us, the providers of mobile crisis in our community. And we, as mobile crisis providers, were consultants outside of the school to the adolescents who were in the halls who had been trained with eyes to kind of recognize when their peers were struggling. And so as much as we're able to create peer mentoring and peer support programs and arming youth with, what do I do if my friend or this classmate of mine is saying, I see on their social media that they're threatening suicide, or that they are really struggling. And oftentimes kids will reach out to other kids before they reach out to adults. So if anything, I think an investment in training kids, more and more kids, to recognize and know what to say would be a useful direction for resources to go.
So that's training peers for early identification of their other peers.
Really kind of knowing when you see a kid who's struggling, or a friend says something, what do you do? Who do you talk to? How do you get them help? So often kids say, I'll tell you this, but I don't want you to tell anyone. And what I tell adolescents when I train in high schools on this issue is, never promise anybody to keep something secret when you don't know what it is. Because oftentimes kids will say, of course, you can tell me anything, I won't tell anyone. And then your best friend tells you, I want to die, and I've stockpiled all of these pills, and I'm going to do it tonight. And you've just said, I'm not going to tell anybody. And then that poor 15-year-old, let's say, is stuck holding, what do I do? Do I break my friend's trust and risk that she'll hate me forever? And this is what 15-year-olds think. Or do I potentially save her life? And unfortunately, sometimes kids are left making that decision with no guidance, and they're just not prepared to do that. So teenagers really do need to be armed with the tools of what to do, because so many kids do sort of use social media outlets and talking to their friends to just kind of outlet their distress. And oftentimes teens feel like it's their responsibility to fix it, and that they have to be the person for their friend. And we try to help educate kids that if that happens, it's not all on your shoulders. Like, which would be better, to have a mad friend or a dead friend? And the kids, I think, sometimes are ill prepared to handle those kind of conflicts. And we really need more kids to understand that there are ways to get help and that you don't have to do this alone.
Okay, this is very helpful. Thank you for waiting today and for a long time. And to me, your testimony was very important, and what your waiting was very beneficial to me. Thank you so much.
Thank you for having me.
Thank you, Madam Chair.
You're very welcome. Representative Wielander.
Hi, Dr. Volperansky. I'm sorry, Potensky. I pronounced your name. I wanted to just again say what Dr. Anwar just said, that thank you for being here with us this afternoon. There are a couple points that when you were speaking, I just wanted to circle back to. One, thinking about where our students and our children have been over this past year, and the isolation and the challenges and the changes and the upheaval and the trauma that a lot of them have faced, and how vitally important assessments like QPR and other types of risk assessments are going to be moving forward. And I'm nervous about the numbers that we're going to start seeing as our schools start getting back into session. And so thank you for bringing that up. And the other, what you were just talking about having your circle of trusted adults, making it, so you have someone beyond your caregiver. That's, I think, something that teaching our students to have in their toolbox of self-reliance, how to advocate for themselves, is making sure that there is that connection. And again, and this is something, some of this comes from some other work that I've done, and giving the students giving them the driving, the steering wheel, letting them be the ones who say, let's bring this program in and let's support this Students Against Violence Everywhere. That's sort of the program that I've worked with that has shifted from adult-led to peer-led. And it's been much more successful in identifying certain behaviors and also giving that kind of support and saying that you are, and if you could sort of speak to that just a little bit more, about giving those tools of that language, like what you were saying, like don't promise anything, sometimes just giving them that agency, and a step-by-step script can be so important. I didn't know if you had anything you wanted to expand on that.
Sure. I think one of the things that we often try to help our teens understand is that what is it that we want? What is it to look for that's not normal? So a lot of times in schools, we really, our eyes gravitate to the kids that are loudest, right? And that make the most disruption. And so in my world, we call those externalizing behaviors, the kids that maybe are disruptive in the classroom or get into altercations and fights. Those kids often get the attention, but what happens is the kids that sometimes are the most vulnerable are the ones that are quietly under the radar. And so it's helping to help kids recognize what's normal for around them and when something is not normal, and then what to do when you see something that makes you concerned. Mm-hmm. And giving them really the language to how do you go up to somebody that you either know really well, your best friend, or someone that you just happen to notice in the hallway that's like in passing and you overhear them say something. Mm-hmm. I have a preteen son in middle school, and he has come to me and said, I was in class and when I had a test and the kid next to me said, I'm so stupid, I'm going to kill myself. What do I do? And this was when he was 12 years old. And so it's like helping kids know he's got a psychologist for a mom, so he knew where to go to, but that's not true for a lot of our kids. A lot of our kids hear that and they get nervous, they get worried, but they have no idea what to do with that information. So helping kids say, if you overhear something, what do you say? Hey, I just heard you say that. Are you okay? And can I what's going on, and then let's go talk to the teacher, or let's go tell, and if that kid says no, that our children who overhear it being able to know, like, who do I go to and how do I say this is what I'm going to do, and like, I wish you would come with me, but I'm going to tell Mrs. so-and-so because I'm worried about you and I care about you. Sometimes we just have to help kids to know what to do with the information that they inevitably get, or they see in 2013, young man in Greenwich committed suicide with a gun. It was a widely publicized suicide. And when that happened, all through social media, there had been multiple signs of threats of harm to self in social media pictures, and people just see them and kids get nervous about them and they don't necessarily know what to do with them. And so we put a lot of responsibility on the adults in the community, but oftentimes kids know faster than we do that something's going on and the way in which they communicate with each other. So really arming youth with the tools, the language, what do you say when you're worried? How do you approach somebody? And then what do you do with the information once you have it? We don't expect youth to solve these problems. We just know that they are the best line of, sometimes the first line of defense to getting kids who need help to help.
I could not agree more. And I think specifically mentioning the difference between tattletaling and speaking out of care is something that is not emphasized enough when we're talking about arming our children with these tools and specifically the actual language to use. So thank you so much for expanding on that. Representative Linehan has had to step away, so I will be sharing for just a little bit longer. Are there any other comments from members of the committee? Seeing none, thank you so much for your time. This was really helpful. I really appreciate it, and I know the rest of the committee does as well.
Thank you so much for taking the time to listen to my testimony and for all that you're doing for kids in the state.
Thank you. It looks like we've been joined by Emma Morelli to close out the evening.
Hello.
Hi, Emma. Welcome to the committee.
Hi, thank you. I'm sorry I'm losing my voice, but I'm going to try to read. Senator Anwar, Representative Linehan, and distinguished members of the Committee on Children. My name is Emma Morelli, and I am a legal intern at the Center for Children's Advocacy and a student at UConn School of Law. The center provides legal representation for underserved children in Connecticut's communities through individual representation, education and training, and systemic advocacy. The center focuses on representing children in child welfare, immigration, juvenile delinquency, public health, and special education matters. On behalf of the Center for Children's Advocacy, I submit this testimony in support of SB 2. The center supports the entirety of the enormous bill placed before you today. As we are all well aware, the pandemic has greatly affected the children of this state on every level. One impact that every parent in the state can relate to has been the impact on our children's mental health, specifically for those who were used to seeing friends and peers every day and have since been isolated via remote learning platforms. As such, I want to specifically focus on sections 1 and 2 of this bill concerning the training of both professional and lay persons working with children as it relates to suicide prevention and mental health screening. The treatment and monitoring of our children's mental well-being is vital to their futures. According to the American Psychological Association, suicide has historically been the second leading cause of death for those between 15 and 24 years of age. The ongoing pandemic has increased this risk. Back in November, the CDC reported that while the overall number of trips to the emergency department for children's mental health had decreased, like many kinds of visits to the hospital during the pandemic, the percentages of total emergency department visits that were specifically for children's mental health has increased. For children aged 5 to 11, the proportion of mental health related visits increased approximately 24%, and for 12 to 17-year-olds by 31%. The increase in emergencies concerning children's mental health can be correlated to the lack of available mental health services combined with the overall pandemic-related stress that children face. This makes it crucial to educate more people to address suicide prevention and mental health intervention. This bill in part aims to do just that by establishing a youth suicide prevention training program and requiring certain licensed health care professionals to complete training in mental health and suicide screening and prevention. In my time with the center, I've been exposed to young clients with significant mental health issues, greatly exacerbated by isolation, as well as children who are facing great challenges with school during the pandemic. It is evident that the children of the state need a comprehensive bill such as this to help navigate the trauma left in COVID-19's wake. For these reasons, the Center for Children's Advocacy strongly supports the passage of SB 2. Thank you for your consideration.
Thank you so much, and you made it through. Thank you for your testimony, and I just personally would like to thank you for bringing, specific attention to the QPR training and the suicide prevention and training, because I think we are going to be facing an overwhelming amount of upset, especially as we move out of the pandemic and amongst our children. Senator Anwar, you have a question?
I just wanted to thank Emma for waiting for the entire day for your testimony and the important work that you're doing. And we can't thank you enough for taking care of the children, but also being an advocate on their behalf and your advocacy work. And I know you'll be you're a law student, right?
Oh, Emma, did we lose you?
Emma, did you hear me?
I just lost the ending of it.
Okay, I just wanted to thank you for waiting, and I wanted to know you're a law student.
Yes, I'm a law student at UConn.
Okay. It's an amazing combination to be an advocate for children and be of a legal profession. So congratulations on your efforts, and then thank you for doing what you're doing. Thank you.
Thank you very much.
Does anyone else from the committee have any questions for Ms. Morelli? None. Thank you so much for waiting until the very end, and we appreciate your time and your attention.
Thank you very much for having me.
You're welcome. I believe that is the end of our testimony for the day. On behalf of Representative Linehan, I would just like to thank everyone for being here today. Senator Anwar, do you have any remarks?
Yeah, no, thank you so much. Thank you for everybody listening to this testimony. I found each and every one of them very useful for me. And I just want to mention towards the end of it, I saw Representative Green's two beautiful dogs. I wanted to just hold them because they are therapeutic sometimes. So again, thank you everybody for being here and listening to that. I love your dogs, Representative Green. They're so beautiful. Thank you. All right. Thank you. Take care.
All right. Thank you so much. Have a good night.